First, I am handing over this with my juniors outside.
Till which date entry mode is there?
Already expired also.
You filed an application?
Yes,
When you filed?
5 days.
ठीक है, कल रख दो. Under application, extension of entry mode. Yes. Next. Item number 1. The matter is listed as to be mentioned for correction in the order dated 11th May 2026. It is informed that in the order dated 11th May 2026, in the cost title, the number of the case is recorded as CRM 331 of 2025 instead of CRR 331 of 2025. In view of the above, in the order dated 11th May 2026, the case number shall be read as CRR 331 of 2025 instead of CRM 331 of 2025. This order we read along with the order dated 11th May 2026. 2. Yes. You are for the appellant, enhancement of the award. Why? When you file the appeal. When you file the appeal. No. 22nd April. Why you not serve the notice? Huh? The appellants have filed the present appeal against the award passed by the Motor Accident Claims Tribunal dated 20th January 2026 in MACC number 124 of 2023, praying for enhancement of the compensation awarded by the London Motor Accident Claims Tribunal, Mal, Jalpaiguri. Full stop. Within time? When you filed? What is the date of the judgment? January. And you filed an appeal? So how many days? What is the time for filing the appeal? So January 21st, January to February, February to March, and you filed on? Huh? 90 days. क्या बोला? Jalpaiguri in MACC number 124 of 2020. Full stop. Appeal is admitted. Full stop. Petition is directed to serve the copy of the appeal along with the documents to the opposite parties. Please the matter. Where is the opposite party? Here only. Jalpaiguri. All are in Jalpaiguri. This is the matter on 20th May 2026. The appellants are directed to file the affidavit of service on the next date, on the returnable date. Next. 3.
At a time for the opposite party, my learned senior is appearing virtually.
Yes.
We are for the opposite party, my lord. Plenty of
Yes.
opposite party.
Who is for the petitioner? Who is appearing for the petitioner?
Mr. Niloy Chakraborty supposed to appear.
Nilay Chakraborty. Paso. Next. 4.
Kashif, I am appearing for the opposite parties first.
Give file. Who is for the petitioner? Huh? No, I will not leave.
I am not engaged in this.
Maybe not engage. If not engage, why you are appearing? In the criminal matters, state advocate is not here. 2 days, you persons have wasted the court time. Now, when the civil case is mentioned, my senior is not there. I will not leave. If you want to argue that, otherwise I will dispose of the matter. Tell your solicitor, I am passing it over. You take the telephone instruction, pass over. Either you argue, otherwise I'll take the matter. Next. 5. Second call, I will not leave any matter. Criminal matters, 2 days you wasted. Five, who is appearing? Also, 6. When you served? 20? What is the report?
Second one. Please certificate of service is incomplete and needs to be uploaded. I have
Item delivered to sender. Return to you.
returned to me.
In which address you have sent?
From the address of
Kanchan Pradhan, wife of so, daughter of so. Can you see the address in the cost title? Deciding at Kamla Jyot. And what is the address mentioned in the communication? Same address. So, how you send this? Can you see the address? And the Master Kumar, how you made the party master? What is the age of the opposite party number 2? You have prepared the revisional application. How you made the directly the minor as a party? In the lower court record, there is matrimonial proceeding. How the minor has been made a party? 16. Hmm. 24 application. And what about the 11A? What is the 11A 13 application? What is your revisional application? Against which order?
order date 10th of February, order number 45, your lordship.
Page 45.
Order number 45, last page. Page 41.
Yes.
Sorry, calling application was 5 papers.
So this is a miscase number. What is the miscase?
The mistake number
19.
Wrong content, your lordship.
Miscellaneous case 8 of 2022. Miscellaneous arising on miscellaneous case, which what is the miscellaneous case? What is the miscellaneous case? What is the miscellaneous case? What is the number of the mat suit?
Number one.
Huh? So this is with regard to the miss case. What is the miss case? 24. Section 24. Can you come to page 16? Page 16. Section 24. And you want to adduce in the evidence in section 24. You are the husband, wife, husband, opposite party. So you are not appeared. Yes. But you are not moved the application. Can you read the order? You have not moved the application when you filed an application. Okay, senior was bedridden. Who filed an application for adjournment? So, court is the post office. You file an application not moved, what the court will do? What the court will do? This practice, this court will not allow. You file an application, your senior is okay. If you moved an application, but the court has rejected, that will be a difficulty. You filed an application not moved when the matter was called, then how the judge can adjourn the matter? Pasua, take back this. Okay, let it be kept in. Yes, sir, Pasua. Next. 7. Yes. You have deposited the amount. What is the 92 lakh 3,722? You are deposited. So it is admitted. Appeal is admitted. Huh? Subject to payment. By which order? No, that's correct. That's correct. Where is the order of the admission? Have you issued notice to the other side? Who is appearing?
Particularly since the last order.
No, he has deposited. She has deposited.
Lordship.
Now the appeal is to be heard.
Now the paperwork and the direction has not been given.
Petition director serve the copy of the memorandum of appeal as well as the application upon the appeal. It is not admitted. By which order it is admitted? There is no order in this record.
Hey.
Without admission, stay. But that should be an order.
Lordship.
That should be automatic. It is not that the substantial question of law, but it is there's some order admitted. deposit amount, issue notice, then hearing. Have you served the notice? You are appearing.
I'm for the claimant respondent.
Claimant respondent.
Your Worship.
You are for the insurance company. What is the ground?
Lordship, may I? Actually, 3% died in a single accident. They have 3 separate cases were filed. They have made payment to the other 2. Now this appeal for the third one.
So why you are not making the payment? What is the ground?
That's because the amount is higher in this case, because the person who died,
But you
you
have
cannot
paid
take because the
you
other 2
paid the
cases
other
are
2.
already paid.
you paid the amount to the other 2 deceased victim or the victim?
Victim,
Yeah. All 3 died.
This is all died. All 3 died.
Once you have given the compensation to the other,
Three
your
cases.
company. Mm. It is not paperwork now, not required
Not
paperwork. Question of law. What is the question? What MSCC? What is the paperwork? The assistant registrar has submitted the report wherein it reveals that the petitioner, the appellant has deposited a sum of rupees 92,03,722. 722 in terms of the order passed by this court being the awarded amount passed by the learned motor accident case tribunal. Full stop. Appeal is admitted. The opposite party is already appearing before this court. The petition already solved the memo of appeal. Let the matter appear when?
Lordship, next week.
Let the matter appear on 19th May.
Grateful, Lordship.
Eight. Can is disposed of.
Deep level, Lordship.
I am under the heading hearing provision. Why? What defect? I am dismissing it. I am dismissing it. You filed the appeal on 6th of January 2025. Have you ordered it? 6th of January 2025, you filed the appeal. Correct. And you have taken time to file an application for Section 5 application. Then matter was taken on March 2026 after more than 1 year.
No.
You have taken time, then case is adjourned till next circuit. Now the matter is taken on 16th April 2026. Again, you have taken the time to file appropriate steps. Then matter was taken on 27th. Again, you have taken time. You have not filed the appeal filed by you is barred by limitation. There is no Section 5. I am dismissing it. Maybe insurance company. So you have not deposited the amount. Have you deposited the amount? Then the appellant, the Oriental Insurance Company Limited has filed the present appeal being aggrieved and dissatisfied with the award passed by the learned Motor Accident Claims Tribunal Fast Track Court, Kuch Bihar in MSCC number 39/2019 dated 19th September 2020. Full stop. When the appeal was filed, the stamp reporter has submitted the report that that there is a delay of 18 days in filing the present appeal. Accordingly, learned counsel for the appellant prays for time to file appropriate application for condoning the delay for preferring an appeal. Accordingly, full stop. Full stop. This court has granted 2 weeks time to the petitioner for taking appropriate steps for filing an application for condoning the delay. Full stop. The matter was taken on 18th of March 2026, comma, the appellant has not filed any application, and on the prayer of the appellant, the case was adjourned till case was adjourned. Again on 16th of April 2026, the matter was taken up for hearing. Again, the learned counsel, full stop. Again, the learned counsel for the appellant has pressed for time. As per the submission made by the counsel for the petitioner, the case was adjourned. The matter was again listed on 27th of April 2026. The learned counsel for the appellant again taken the time, again prayed for time, and this court has adjourned the matter. Full stop. The matter is listed today. Full stop. When the matter is taken up for hearing, the learned counsel for the petitioner prays for time to placing the matter before the next circuit bench. Full stop. This court finds that the petitioner has neither deposited the statutory fee of rupees 25,000, where it is. This court finds that at the time of filing of the instant appeal, the office has noted that the appeal is barred. Appeal has been filed after the period of 18 days. Time and again for the last more than 1 year, the petition has taken time, but the appellant has not filed any application for condoning the delay. Accordingly, this court finds that the appellant is only to kill the time to avoid for making the payment in terms of the award passed by the London Motor Accident Time Tribunal has filed the present appeal. Accordingly, the appeal is dismissed and barred by limitation. Next. 9. Yes. Extension of time. What is the amount you have paid the statutory amount? Appellant has deposited statutory amount of 25,000. There shall be an interim stay of the judgment and award dated 9th January 2025, passed by the London District Judge. The company shall take a step for deposit the interim amount along with the interest. That is on 12th of December 2025. 6 months your company is not able to deposit the amount. When the check has come, it has not been. So why you are not deposited in the registry?
Subsequently, I have filed this application.
These all are beneficiary legislation. You all insurance company after the award file the appeal, either condonation of delay, not file the application for condoning delay, not you are filing the amount depositing before the court. If you are having a bona fide appeal that could have been come with the appeal along with the total awarded amount, what is the law now?
As an answer, 4 weeks time, not in the meantime, we will.
4 weeks time. Sorry.
It has to come from Kolkata.
Maybe. Kolkata, what is the date? 2 hours, 1 hour? Get it the draft, come with the evening flight and deposit tomorrow. If you deposit tomorrow, I will fix the matter tomorrow. Or I will fix the matter on Monday. Otherwise, I am dismissing it here in now. For amount, What? You have to go to the bank and make a demand draft or nowadays RTGS? So, yeah, it is your act. Why the claimant should suffer?
Not appearing, Lordship.
Maybe not appearing, you are not issued the notice. The court is here to see the claimant. January 2025 award was passed. You filed the appeal when? Maybe time, but when you file the appeal? March 2026, then? No, March 20, where is your appeal? (24/4), yes, then 1 year has been passed.
This is the lesser part.
And that's why I am giving you option. I am keeping on Monday. You tell your company to transfer the amount. You take the account number from the registry, transfer, give the detail. I will record you.
Registry wants the demand draft. Lordship.
Okay, demand draft, it is very easy. Within 1 hour. Last I am not. No. I know on Thursday what will happen.
Lordship.
I am fixing on Tuesday maximum. If you take, give the undertaking, otherwise I am passing order here in no. No further. Learned counsel for the petitioner press for time till Tuesday to deposit the awarded amount. According cases adjourned, let the matter appear on Tuesday under the same heading.
Today, which matter I have mentioned, Lordship, same. Today, which matter I have mentioned, Lordship, same, Lordship. In that matter, also same problem.
What can be done? Come. 10.
Lordship, I am for the claimant respondent.
Yes.
I am on behalf of the applicant insurance company.
Hmm.
Today is fixed for here the CAN application
What is the can?
for stay. There was a,
What is the total awarded amount?
there was an identity
What is
order.
the awarded amount?
Lordship.
Lordship, can I see the order dated
Already the amount has been deposited. Lordship.
15/12/2025.
25.
15/12.
Yes.
15/12. Just can I see the order?
15/12/25.
25, Lordship.
In terms of the honor, please to report whether any, and report that 13,48,000 has been
Yes.
deposited.
Yes, that has been deposited. Can be disposed of and direction may be given for calling the TCR.
Lordship, here,
What are the ground?
Ground that implication of the false vehicle.
Huh?
Implantation of the vehicle. If it was lost taken one vehicle and charge sheet was subsequently filed against another vehicle.
Have you taken that plea in the
Yes,
written
yes,
statement?
yes.
Yes. The vehicle was not involved in the accident.
No. That is our case.
no, Lordship. Totally
That is our
not.
specific
So what is the
ground.
necessity of the TCR? I will hear it.
Documents are required.
What document is
Lordship, not
required?
if the memo of appeal has not been given even.
What document is
And
required?
Kali
What
says,
document you rely upon?
All documents are required, Lordship.
What
because
document you tell me?
if a
What
acci-
document
if a
in the
acci-
MSCC case? What document
if
is required?
accident is-
Huh?
Without TCR, Lordship cannot produce the FIR, CR list, charge sheet and the.
I am asking whether you have taken the plea for that this vehicle was not
Yes,
involved.
that was taken,
Ah.
that's produced before your Lordship.
Hmm.
Without TCR, that.
Which exhibit? Show me. Which exhibit? In the exhibit might have been recorded in the order award. Which exhibit you have showed that the vehicle number is so and so? Which exhibit? What exhibit you have shown?
In the memo of our specific plea, this is our plea that
Show me.
Lordship at,
Plea means
At
you
the-
have
at-
to
at-
adduce the evidence before the MSCC,
yes, Lordship at our
before the tribunal.
para 9 of the stay application, Lordship.
No, in award. Award. Where is your defense? Show me the award. You have taken the defense that vehicle number so and so involved, but the tribunal has. Show me where is the defense in the before the tribunal.
Actually, Lordship, the number of the vehicle when the FIR was lost was little problem. Then subsequently, FIR was lost
Vehicle
regarding the original number. Investigation started. Charge sheet submitted against the original vehicle. Case started, and this plea was never taken in the trial court.
Lordship,
So-
TCR is required because all these document evidence is.
That's why I'm asking you satisfied this court TCR with regard to what document?
all the evidence, the cross, the FIR,
Show me your
our
Show me from the award. This document has not been considered
Then,
by the tribunal. Show me from the
Then
award.
liberty may be given, we will file the paper annexing all the documents because that has to be produced before lordship.
Lordship, one in the.
And that
Tell
can,
us is para 7 of the order dated 15/12/2025. Para
Yes.
7.
Yes,
While disposing can 2.
along
no,
with the
can do is
interest.
not disposed of.
Hmm.
Can do,
The insurance company shall take steps to deposit the entire awarded. What is the awarded amount? 9 lakh.
lordship,
9,58,740 along with the interest.
interest.
So they have deposited 13 lakh.
Yes.
Because no copy has been, even the memo of appeal has not been served.
That is
upon
to
us.
be deposited with the accounts
The
department. not
13 lakh,
Yes.
up till which date the interest was calculated?
Up to the date of deposit, lordship.
Where is that, where you mention in the can 2?
No, no, can 2 was filed earlier. The action was given.
That's the problem.
The petition, the appellant has filed an application being can 2 of 2025, praying for stay of the impugned award passed by the Learned Motor Accident Claims Tribunal dated 5th of December 2024 in MACC number 23 of 2019. Counsel for the petition submit that in terms of the order passed by this court dated 15 December 2025, the petitioner and the appellant has deposited the principal compensation amount of rupees 9,58,474 along with interest total in rupees 13,48,459. 459. Full stop. The office has submitted the report wherein it is found that the petitioner has deposited an amount of rupees 13,48,459 by challan number 82 dated 8th of January 2026. Full stop. In view of the above, full stop. In view of the appeal is admitted. In view of the above, the impugned award, the operation of the impugned award is straight. Full stop. The appellant is directed to serve the copy of the appeal along with all documents to the opposite party / claimant within a week from date. Full stop. The Learned Motor Accident Claims Tribunal. The Learned, what is the Learned Motor Accident Tribunal within bracket Additional District Judge Fast Track Court 1 Alipurdwar is directed to send the department is directed to call for the record of MACC case number 23 of 2019 from the Learned Motor Accident Claims Tribunal within bracket Additional District Judge Fast Track Court 1 Alipurdwar within 2 weeks from date. After receipt of the lower court record, the parties are at liberty to mention the matter for RDRD. Can number 2 of 2026, 26, 25 is disposed.
And they have already said to check, but they will try to take as a Jalpaiguri lordship. The impugned order has already expired. Since the case of Chula Bandla, the head of this is changing lordship. In 2-3 days, because we need the today's order for cancellation, the earlier check lordship, then the company will issue the.
This court is not taking any risk. I have given till Tuesday as for your you bring. I don't know, madam. What you are telling as on today, all are online. All are online. What you are telling? Yes, call the matter. I don't know, 11.
Well, that for the opposite party, the landlord.
Item number?
11.
Yes, you are for the,
I'm for the
who is for the
landlord.
appellant?
Tenant file this appeal.
You are for the? Yes, where he is? Okay, you start. You start. 2 days I adjourn all the criminal matter, but I will not adjourn the civil matters. I already morning stated because of civil matters, there is no requirement of the PP, APP, government pleader. It is of the dispute of the private parties. You tell, otherwise I will request the Chief Justice to close the circuit bench. You persons are neither able to do the civil matters nor able to do the criminal matters.
My lord, may I suggest one thing, subject to your lordship's consent, lordship.
Only one question, whether the partnership has been proved or not.
My lord,
Nothing
yes.
else.
Nothing.
Anything is there.
Nothing. proved,
Then
lordship.
the defendant
Yes,
number 2 is the partner, whether the partner is
No,
having
it's
the
a
right
parted-
to
They have parted
right
the
to
possession.
continue the property as a tenant.
They have
That is the
part-
only question.
Yes. They have parted the possessions under
Nothing
the
is
guise
there.
of partnership firm.
I am passing it off. Come.
Second report.
Yes, second appeal. That's why I already frame. I already put frame the question. Only one question: whether defendant number 2 can continue as a partner, as a tenant in the premises.
On Friday.
I talked with my senior, he engaged some instruction because for me, I can, otherwise I cannot argue. Kindly,
2024 SAT.
we are,
And it is not that it is today it is listed. It was listed before the court number one for the first day itself. So why you not ready? It is not, you cannot take the plea the first day it has been listed.
Yesterday he come, but my
Okay, come tomorrow to as per the prayer made by the counsel for the appellant, the case is adjourned. Let the matter appear tomorrow as a specially fixed matter. It is made clear that no adjournment shall be granted on the date fixed if none appears on behalf of the appellant, the second appeal will be heard on merit, will be disposed of on merit. Next.
Well. This matter, lordship, it has come for the first time. Lordship, kindly give this 2 or 3 days time to prepare myself. I'll do the matter. And my lord, the
Lordship, the paper book has not been handed over to me.
serving it today.
Where is the paper book?
I have, but
Who is preparing the paper book?
I am the, my lord, the appellant.
Hmm.
My lord, today only I have come to learn that Mr. Ganguly is appearing for the respondent. So, my lord, I'm handing over the paper book today. Give me 2 or 3 days, my lord, one day, lordship.
Learned counsel for the appellant submitted, paper book is ready and filed in the court. Learned counsel for the opposite party submitted, no paper book is served. Full stop. Counsel for the appellant is directed to serve the paper book to the learned counsel for the opposite party in course of the day. List the matter. List the matter on 18th May for hearing, under the heading hearing. Next. 13.
My lord, I am for item number 13 for the Reliance General Insurance Company, my lord. My lord, can you hear me?
Yes,
My
yes,
lord,
yes, I can hear you.
My lord, I have deposited the entire awarded amount on 25/4/2025, my lord. The entire awarded amount I have already obtained stay, my lord. But thereafter, I missed the list and it was dismissed. And then again on 17/2/2026, the appeal was restored along with all the applications. My lord, meanwhile, this Reliance General Insurance Company has been taken over by IndusInd General Insurance Company, my lord, and that's why I'll have to file an application regarding the change of name of the appellant. My lord, kindly give me some time. Next circuit bench, my lord. Thank you.
Sorry. This court will not
My lord-
allow any adjournment. You
My
put
lord,
up in
I'll
prepare
have
your.
My lord, I'll have, since Reliance has been taken over by IndusInd, my lord, the name of the appellant
That
has
might
to
be
be
that
changed.
might be taken, but the record is there. Record is not changed. Record is there. Advocate has to argue on the behalf of the record, not by the company.
My lord? My lord,
You
I
have
did
to
not-
argue on the basis of the record, not on the basis of the company's document. Whoever the
My lord,
company, the record is there.
My lord, the name of the appellant.
Who is for the
Reliance-
claimant? Who is for the claimant? Yes.
I am for the respondent 5, Lordship.
My lord, this is an quantum appeal and contributory negligence. And my lord, if there is any enhancement in the award, or there is some lesser amount is paid, my lord, then it will be difficult, because Reliance General Insurance Company is no more. The appellant has been done, Reliance has been taken over by IndusInd. My lord, kindly appreciate, my lord. An application has to be made, my lord, regarding the change of the name of the appellant.
When you deposited the awarded amount,
I have deposited
When
on
you-
25/4/2025. More
25,
than 1 year. 2025.
24?
25/4/2025.
There is no report.
Yes, my lord, there is. The challan must be there.
That's why nothing is there, madam.
My lord, the challan
There's
is there.
nothing
in
on
the
record.
My lord, the challan
There's
is
no-
there in the record. 94 lakhs I have deposited. 94 lakhs 81,734. Challan number 11 dated 25/4/2025. My lord, kindly, the record is there. My lord, the challan must be there. Kindly see.
Can you come out from the screen? Once the court is having all record, court is telling that there is no document regarding the proof of the deposit. You are telling that on record.
My lord, the challan is in the record, my lord. Kindly see, my lord. Because
See,
that's
in
why
the
I
record is there. See the challan is there or not?
challan number 11.
She is from Jalpaiguri or from Calcutta?
I'm from Calcutta, my lord.
So, madam, you don't know how to address the court.
My lord, I did not.
You are from the principal bench. You don't know how to address the court. You are the senior person.
My lord, I have already
You are
deposited.
arguing with the court. When the court is telling that there is no challan in the record, then you are arguing with the court.
My lord, I have the receipt of the challan.
You might have been received. You not filed in the court.
My lord, it has been received by the account section of the Jalpaiguri
That's
High
the
Court.
report also, account section.
My lord, kindly keep it a day after tomorrow. I will check.
You know any person here in the Jalpaiguri who can produce the copy of the challan so that I can call for the report from the department.
My
You are
lord,
not
at least-
having.
My lord,
You are
at
not
least
having
give
any
me-
junior here.
My lord, at least give me 1 day time. I will find it out.
उसको नहीं मालूम होगा. Record and order. Learned counsel for the appellant submit that the appellant has deposited the challan amount of rupees
94 lakhs 56,734.
by challan number
11.
dated
Dated 25/4/2025.
25/4/2020. The department is directed to submit report whether the appellant has submitted the amount and deposited the amount by challan with the above before this court. Let the report be filed on 19th May 2020 by 19th May 2020. Leaks the matter on 19th May.
I'm grateful, my lord.
Next.
I'm deeply obliged.
एटर डिपार्टमेंट वो भेज देना आप अपना पास मत रखना. नेक्स्ट
14. Lordship, I am for the appellant, and item number 15 is counter appeal by the insurance company. I am ready.
Have you served?
Yes.
Where is the
Everything done.
affidavit?
Paper book, everything done.
They are appearing.
It is,
Abir Biswas respondent.
it is for hearing. Lordship, lawyer of the insurance company.
Your
intimated
insurance
me,
company.
he is coming. He is
You are
coming.
appearing for
I am the claimant.
claimant.
Item number 14 claimant and item number 15 I am the opposite party.
No, item number
14
14 is of the claimant. side.
claimant.
And item number 15 is the
Insurance company, appeal of
Insurance
insurance
company,
company, I am there, I am opposite party.
which for the appeal? Huh? 15 you are for the appellant. Okay, both the parties.
Lordship, I want to file the paper book.
এই 14 থেকে 15 করো।
Sorry, Lordship.
No.
I'm in item number 17.
Item number
17.
17. So you have not, you have prepared the paper book?
Lordship, I have given already.
The paper book আছে কি?
In record.
আছে।
यही तो प्रॉब्लम है। किसमें है पेपर बुक? Item number
14.
14. Have you served? But item number 15 no is there.
Lordship, he just requested me to take passover, he is coming.
Okay, pass so. If the both party will come, I will take the matter.
Lordship,
No.
can it be taken at 2 p.m.?
Let's see.
Oh, Lordship.
Let the other party come.
Lordship.
16.
Lordship, I am for the appellate insurance company here.
Yes. Who is for the claimant?
This is the affidavit of service.
You are the claimant.
No, I am for the insurance.
You are the claimant. Claimant has challenged the award.
No, insurance company.
Insurance company.
Insurance
I am
company.
challenged.
Yes. Have you deposited the amount?
No.
Why? It is not
Can is
admitted.
pending, Lordship. Stay can is pending. If my Lordship will directed, I will deposit the amount.
You prepared the paper book?
Yes.
The paper book?
Yes.
সাতটুকু বসে দেবো জিত কিন্তু 1 to 5 claimant 1 to 5 6
You deposited only 25,000.
Yes.
There's no stay.
No.
You prepared an execution before the award, before the time, no?
no
No. Yes, ready? You are ready?
Ready?
Yes. You are the appellant, sir.
The grievance point is that, Lordship, the only grievance point is that the tribunal did not consider that just only they have produced only one document.
That case.
Salary certificate.
case.
In this case. আজকে করবি তো নাকি কালকে নেবি? Ready আছে?
কালকে
Yes.
Lordship, can it be, they are not actually prepared.
You start, you are the appellant. I will see whether they've been called for or they have to be called for or not.
Okay, Lordship.
Where is the award?
Award is about 26 lakhs.
Where is the award?
Page,
Paper book?
paper book, in 16, Lordship.
Page 16. How many claimants? 4. 5.
Right.
Who father died?
no not husband died Petition number one,
That's why husband
Yes.
and the wife and
Hus-
children of
children and father and mother.
Well, he was a government servant?
No,
No.
private, sir.
Private. Yes.
Without any documentary evidence,
Hmm.
just on oral evidence,
Hmm.
Lordship, the tribunal awarded the salary, fixed the salary.
Hmm.
So, insurance company's plea is that
Hmm.
without any document, some documents are required, only handwritten without any date. They have supplied the documents without date, without anything,
Hmm.
and relied upon 12,000.
Where is the calculation?
Calculation on page
So you are only with regard to the quantum.
quantum,
Only with
Only
regard to the quantum.
quantum.
Yes. Come to the where is the calculation?
page
Page,
Page 526.
Yes, 25 paragraph 2. Paragraph, yes,
Uh-huh.
start.
Hmm.
So considering the social economic context, at the time of his death, now 12,000 per mensum
Per mention.
as monthly salary of the
Monthly
deceased
salary.
during the lifetime cannot be a aberration, so the ultimately death of the company.
Page 60, Lordship, can you paper book?
Page 16,
60.
60.
60.
Yes.
That is the salary certificate. That is, in this point, we are disagreeing. Is this a salary certificate?
To whom is some concern? What is recorded here? What is recorded? Read.
Date, exhibit 5/23 without 15/10/2020.
What is the exhibit number?
Exhibit number, it is
15.
15, Lordship.
15.
1.
Yes. What is written in the Bangla language? Read the
That-
certificate.
এত দ্বারা আমি অনিল চন্দ্র পিতা অমুক অমুক ক্লাব ধূপগুড়ি অমুক, তিনি আমার কর্মচারী ছিলেন, 4 বছর ধরে কাজ করছিলেন।
হুম।
আত্মীয় জানতে পারলাম তিনি মোটর গাড়ি দুর্ঘটনা হয়েছে, আমি তাকে 12,000 টাকা করে দিতাম
12,000 টাকা
দিতাম
দিতে হবে। ঠিক আছে?
It would be national income,
So who has issued this certificate?
to a অনিল মন্ডল।
Anil Mandal. He examined.
Exact.
Where is the PW? Where is
PW.
his evidence?
আলাদা। Page
Where is the PW?
15.
Page 15.
15.
15.
Lordship, can you see that? The document is not in my handwriting.
Just a minute. I am the owner of Kanchenjunga. On that day, one day after working in my shop, he returned to. I knew Ganesh Verma. He used to work in my shop as carpenter since 2016. He died in the Rotterdam. I used to pay 12,000 as salary during the entire work. This is the original trade license photocopy. This is the original. This is the return after 6 months. This is a certificate I issued to the official in the official pad of my shop, my signature and seal. Certificate I certified the 12,000 salary. Yes.
Cross, Lordship.
Yes. What is the cross? Document is not in my handwriting. No problem. Then
There is no signature in the document.
correct.
That is the problem.
Correct. Then
That is the problem.
so
I can recall the documents of 15-14 documents issued in that date.
Hmm.
He is not reliable at all. If there is no, he is giving his witness
Hmm.
and clearly say that this is not my signature. How can I believe the court, that learned tribunal believe this? And in that case, Lordship, in the cross last year, first page, the OP insurance company showing the photocopy supplied to him submits before the court the photocopy date has been omitted without any date.
So this is
This should be a notional income on the
page 15 is a
Yes.
complete document.
subject
Page 15 is a complete document.
document, complete document.
Where is the concluded of the cross exam? This is
Oh.
all.
Lordship
Where is the
is
second
a-
page?
Yes.
Where is the
yes.
second page? LCR
Second.
RCT?
LCR. This is my mistake, Lordship. Please mercy. Oh. I haven't certified copy, Lordship. I'm just. Lordship, I haven't certified copy, Lordship. Lordship, can I supply this is the certified copy?
But at the time of exhibiting the document, you're not objected.
Object, I will cross and
objected.
objected.
You're not
But-
objected.
But I am just giving the.
And you're also not given any suggestion that he was not the worker of the paid what is
Denying all the things.
that? Where is the
Last-
suggestion to show that he was not the employee working in your shop? Where is such a suggestion? Where is the suggestion?
Just. Lordship, last page, I think.
Take this.
I have not a fact that I have issued the salary certificate
Hmm.
and on the request of the family members
Correct.
of the, I am saying that he is issuing this certificate.
Issuing certificate is different. You show me where is the suggestion that he was not working in your shop? Where is the suggestion? Only stated that you issued the certificate.
That is our point.
Keep with you. Keep with you. So
That is our point.
then
That is our point that.
challenging
he-
one
he-
document. See, challenging one document. There are three cardinal principles. First, the document at the time of exhibiting it is to be objected. Second, on what ground you objected, you have to put on cross. Third, it has to be sent to the plain whose document, then it is a duty to prove it. If you are not challenged that, so how the
I am challenging the total. I am saying that, Lordship.
where is that? It is a forged document. Total if it is
I have issued the salary, not a fact, he is saying that it is not a fact that,
what?
and he is not remembering anything. So how
That
can
is different thing.
and he is saying that the salary certificate on request of the family.
Yes. Any further?
And that is the main point.
Any
Lordship,
further?
and-
Any further argument?
another point. Just. And the interest portion, Lordship,
Where is your memo? Where is the memo of appeal?
memo of 32.
32.
32 starting. Lordship.
6.5%.
6% will be.
Now it is 9%.
No, Lordship, all. you
Yes.
have already-
How you approve the certificate?
Only my delay one judgment, my lord. The petition claimant is the wife, minor children, and my lord, father and mother, my lord, of the deceased.
The one, the Mani Barman is wife.
Yes, my lord.
Mani is wife.
Yes, my lord.
And
2
Gaurav,
and 3 is the children, my lord. Son
Huh?
and daughter.
who?
Son, two
Two
son and 3 daughter.
son, 3 daughter. One
4
is
and
wife.
5.
4
4, 5, my lord, for father and mother of the deceased.
father and mother.
Yes.
How father has come? How father has come?
Suniti Gorgon, wife of the Manik Gorgon. Yes. Father and mother. Suniti Gorgon, wife of Manik Gorgon. Mother.
Where is the award? Where is the award?
16.
Huh?
Resignation of
60.
16. 1 6. Of paper.
It is the
Yeah.
Yes. Yes, what is the submission?
Lord. Ada good. And that has been considered by the tribunal. That has been considered at the time of hearing.
Correct. You're not challenged.
They have also not challenged.
But this challenge only part of the salary, amount of salary.
Salary.
Yes, anything further?
That was proved, my lord.
Lordship, my submission is that something, if it is so easy that someone had come and something, what is if this type of thing is
Yes,
happening?
That's I totally appreciate your submission.
My submission
But
is that.
during the cross-examination, you have to bring your own defense. If you are challenging the certificate, you could have been objected to. You have not objected. So, if once you have not objected, then the 50% burden of the claimant you have considered. Secondly, the claimant has examined the person who has issued the certificate, signed the certificate. And the signature which you are not denying with regard to the signature, it is not issued by you. Third,
Yes,
you have not put the suggestion that he was not working as a carpenter in your shop.
My lordship,
Correct. Only by saying that the certificate has been issued falsely.
also,
So
that is
will
our
not-
submission.
Will not submit. You could have been, see, whatever the suggestion you're conducting the trials. You're conducting the trial. For the conducting the trial, whatever the suggestion you are giving, that is to be corroborated with the other facts. So that you can prove at the time of argument, yeah, this is my fact and this is my suggestion, both are corroborated. That's why my cross-examination is to be taken into consideration.
If anyone saying that this is not my son, I have not written this in a doc, how
Okay.
can we believe it, Lordship?
The
It should be notional income, Lordship.
The insurance company, namely, which insurance company?
Oriental insurance.
Oriental Insurance Company Limited. The Oriental Insurance Company Limited being the opposite party. Who is the Santosh Kumar Sharma? Driver, owner?
Yes.
No, owner.
The
Owner of the
Oriental
vehicle.
Insurance Company Limited being the opposite party in the motor accident claim cases number 366 of 2020 has filed the present appeal, being aggrieved and dissatisfied with the award passed by the learned Motor Accident Claims Tribunal, First Court, Jalpaiguri, dated 2nd September 2024, wherein the learned tribunal has directed the insurance company to pay an amount of rupees 26,40,400 being the compensation to the claimants along with interest at the rate of 6.5% from the date of filing of the case, that is on and from 16 December 2020. Full stop. The insurance company has filed the present appeal only on the ground that the London Tribunal has considered the monthly income of the deceased. This is of rupees 12,000 by relying upon the certificate issued by the
PW3.
Issued by one
PW3.
issued by PW3, namely, issued by PW3, namely, give the certificate copy. Yes, PW3, namely, Anil Chandra Mandal, namely Anil Chandra Mandal, being the proprietor of Kanchanjunga Furniture. Being the proprietor of Kanchanjunga Furniture, being exhibit 15 बोला होता है. Furniture. क्या बोलो पूरा वर्ड बोलो ना ऊपर हाँ which is marked as exhibit 15. Exhibit 15. Learned counsel for the petitioner appellant submits that the learned tribunal ought to have considered the notional income instead of the income of rupees 12,000 in terms of as per exhibit 15. The learned counsel appearing for the insurance company has drawn the attention of this court to the statement, to the evidence of the PW3 who has issued exhibit 15 and submit that during the cross-examination, the PW16 and PW3 has stated that the document is not in his and writing. And in the document, there is no signature of the subscriber. Full stop. He further submits that the PW3 has not submitted any document that the PW3 has deposited any amount under the Employees Compensation Act to prove that the deceased was working under PW3. Full stop. He further submitted that in the cross-examination, the PW3 has further stated that he never deducted any amount as a professional tax or provident fund from the salary of the deceased. These are the salary of the deceased. He further submitted that he has categorically put the suggestion that he has issued the said certificate only on the request of the family members of the deceased to get the compensation from the landed tribe. Eta pin korun, stapler korun from the police. The landed counsel for the insurance company further submit that the landed tribunal has also wrongly awarded the interest at the rate of 6.5%. 6.5%. The full landed counsel, he submitted the award passed by the landed tribunal is required to be modified by considering the notional income of the deceased instead of the amount of rupees 12,000 per month. And the interest awarded by the landed tribunal is to be reduced from 6.5% to 6%. Landed counsel appearing for the claimants opposite parties therein submit that the deceased was working in the Kanchanjunga furniture as carpenter, and he was earning rupees 12,000 per month. Full stop. Due to the death of the deceased, the total family member are facing great difficulties, are facing severe financial difficulties, as the deceased was the only earning member of the family. He further submitted that he was working as a carpenter and he was getting salary rupees 12,000, and accordingly the PW3 has issued the certificate certifying that the deceased was working as carpenter with the PW3 and he was getting salary of rupees 12,000. Landed counsel for the claimant submit that the during the submit that the claimants have duly proved the certificate issued by the PW3 being Exhibit 15 by examining the PW3, who is the proprietor of Kanchanjunga Furniture, and he has issued the said certificate. He further submitted that Mayor, he has not written the certificate, but he has identified the signature in the said certificate, that is in Exhibit 15. And during his evidence, he has categorically mentioned that the deceased was working as carpenter in his shop from 2016 to 2000, and he was getting salary of rupees 12,000 rupees per month. The landed counsel appearing for the claimants further submit that the insurance company had cross-examined PW3, but he has not put any suggestion that the deceased was not working with the PW3 as carpenter, or he was not getting rupees 12,000 rupees from the PW3. Learned counsel for the claimant submit that the learned tribunal, after considering the evidence led by the claimants and the documents produced before the learned tribunal, has rightly passed an award directing the insurance company to pay the amount of rupees 26 lakhs 40,400 along with the interest at the rate of 6.5%. He further submit that the learned tribunal has awarded the minimum interest at the rate of 6.5%, and as such, the insurance company has not made out any case for deduction of any quantum of the interest amount as awarded by the insurance company. Had the learned counsel for the respective parties peruse the materials on record. The insurance company has filed the present appeal only on the ground that the learned motor accident claim tribunal has wrongly considered the certificate issued by the PW3, which is Exhibit 15, wherein it is certified that the deceased was getting the salary of rupees 15,000 per full stop. This court considered the evidence of the PW3, wherein the PW3 has categorically mentioned that he knows the deceased, namely Ganesh Burman. He was the deceased. Ganesh Burman was the deceased.
Yes.
Ganesh Burman, and he used to work in his shop as carpenter since the month of December 2016 till 2020. 2020. During he has also stated that he has issued the certificate in his letterhead. And he has also certified that the deceased was getting rupees 12,000 per month and getting the salary of rupees 12,000 per month. The certificate is marked as exhibit. Marked at exhibit 15, and the signature of the PW3 is marked as exhibit 15/1. At the time of evidence of the PW3, who has issued the certificate dated 15th October 2020, that is exhibit 15, in presence of the learned counsel appearing for the insurance company. Though the insurance company tried to make out the case during the cross-examination that the PW3 has not deposited any amount under the Employees Compensation Act, or he has not deducted any amount with regard to the Employees Provident Fund or any other provident fund or any other professional tax. The insurance company has not put any suggestion to the PW3 that the deceased was not working as carpenter in the shop of the PW3. The learned counsel appearing for the insurance company has also not put any suggestion that the certificate that the that the deceased was getting the salary of rupees 12,000 per month. Considering the above, full stop. This court find that considering the above, this court find that the insurance company had an opportunity to challenge the certificate being Exhibit 15 issued by the PW3. Though several questions have been put to the PW3, but they have not challenged the certificate by putting any question that the deceased was not working with the PW3 or he was not getting the salary of rupees 12,000. In the presence of the counsel appearing for the insurance company, the salary certificate issued by the PW3 was exhibited, big exhibit 15. At the time of exhibiting the said document, the learned counsel appearing, the insurance company has not objected for the exhibiting the said document. On the other hand, the learned counsel, the claimants have proved the certificate by examining the PW3, and he has identified the certificate along with its signature. In view of the above, this court did not find any illegality in the as regard the interest. This court find that the learned tribunal has awarded the minimum interest of rupees 6.5% from the date of application. And as such, this court did not find any illegality in the impugned award passed by the learned motor accident claims tribunal. First court Jalpaiguri, dated 2nd September 2024, passed in MSC case number 366 of 2020, according full stop, FMAT. What is the number? FMAT within bracket MV, FMA 19 of 2025 is dismissed. No order is
Good. Lordship, where will deposit the amount?
No, it is new. The insurance company has deposited the statutory amount of rupees 25,000. The claimant has liberty to withdraw the said amount. Full stop. If the claimants file and request the registry for release of the said amount, the registry shall immediately release the said amount on proper vendor identification. 17. Yes. None appears for the parties. Let the matter. Next circuit bench. You are appearing for?
I'm the appellant.
Filing
the paper.
You're filing the paper book. You are the claimant or insurance company?
Clement.
Claimant has prepared an appeal
Yes, sir.
against the award.
Yes, sir.
Have you served the paper book?
Yes, sir.
Yes. What are the grounds? Where is the memo? First you show the award. Where is the award? Hey.
Page 39 onwards, sir.
39.
Yes.
How many claimants were there?
Only one claimant.
One claimant. Who is he?
She is the mother of the deceased.
Mother of the deceased. Deceased was unmarried.
Yes. Yes, sir.
He was unmarried. Whether he was a government servant?
No, he was a daily laborer. He
Daily
was
laborer.
used to work in a agricultural field. And
Where is the award? 36. 39. Where is the awarded amount?
Operating
7,56,000.
yes, 7,56,000.
7,56,000. Totally 7,86,000.
7,86,000.
So why your challenge on what ground? What are the grounds?
Yes, sir. Don't call me then.
Where is your appeal?
Appeal start from page
48.
50.
48.
48.
40?
48.
48. What are the ground in the appeal?
Kindly come to
Before passing out on the document, the should be considered income of the deceased.
Notional income has been assessed.
5,000,
Yes,
which is much lesser. Should have been granted 40% of the total assessed compensation. 30,000. Insurance damage. Or to have ordered at least 1 lakh on account of the general damage. 12%. So what is the 5,000 years consider
5,000.
as notional?
For
Notional.
Yes, for unskilled labor, minimum wages now is 375.
375.
Yes,
So how
sir.
it will come? 10,350.
10,500.
10,370 or something. How the notional income will 5,000? Nowadays, what is the minimum wages now? In the West Bengal? Skilled Mazdoor, unskilled
For
Mazdoor?
unskilled, 370.
Unskilled?
Actually, Lordship, he was working the field. He was the
Maybe.
working the field.
Maybe.
Only 20 years.
Which insurance company?
This company
Cholamandalam.
Cholamandalam.
So, 5,000 nowadays. You consider the recent judgment, your judgment?
No, Lordship, right now I don't.
Sridham versus in New Indian Insurance.
Unskilled.
10,386. That's why the latest judgment. So,
I will bring the judgment.
when you will bring the judgment? You are ready, not ready today?
Kindly take it up tomorrow.
Why? Yes.
Lordship, 5,000.
Where is the calculation? Where is the calculation? $5,000 per month, 40%, adding 40%, that is no problem. 40% no problem, but that is the equal. So what further? What is the further? Interest not granted.
Interest
6% grant.
6%.
Pranay 15,000, 15,000 no problem. Then general damage 30,000. So how you whether you approved general damage? Was examined. How you approve the general damage? You are asking for the 1 lakh rupees. How you approve the general damage? He was unmarried. He was unmarried.
Yes.
So, and who is the claimant? Mother.
Mother.
So father is there. And interest, where is the interest?
Interest only 6%.
6% per annum from the date of filing. Okay. Yes.
Lordship, only in the portion of income, notional income.
How the notional income calculated? Show me. I have no problem. Show me how the notional income can be calculated. I will accept your submission. Show me the notional income calculation. The notional income 5,000 rupees.
Lordship, here it is considered 5,000 rupees.
How? That's why. How?
It was the practice then going on.
Practice before the court. There is no practice. There should be some.
आगे चुप
ये एक था ना सुबह पासवर्ड मैटर्स नहीं जजमेंट लिख के रखा था आपको कहाँ से मालूम है
20
देखो उसको पीछे खोल दो खोलो हाँ record be sent back.
Yes.
And the claimants are liberty to take appropriate order. Yes. There's a latest judgment.
No, sure, I will bring the.
10,386. I have, but I don't know where they have kept. You persons are not getting ready all this matter. You file this without the citation, you are arguing, you have prepared the appeal. How you have prepared the appeal? What the Pranasati said?
Pronouncement is considered.
Pranasati is considered with the federal expenses and estate. Subsequently, what about the notional income, and if the income is not put, how it is to be taken into consideration, the amount?
The citation is 6 January 2026.
I could not because come tomorrow with the judgment. You also consider how.
Lordship, day after tomorrow. Tomorrow I shall. Day after tomorrow.
Atul Tiwari. It's
Day
not
after tomorrow.
reported. Atul Tiwari. Regional Manager, Oriental Insurance Company.
Atul Tiwari, no?
Dated, what is the date?
6 January 2026.
Regional manager, which
2025.
which insurance company?
Oriental.
Not reported.
6 January 26, na? 25 or 26?
No, 25.
20. Oh, there is another one judgment. Yes. Come ready tomorrow, day after tomorrow.
Day after tomorrow.
Next.
18. There's no recent.
Call 18. 18.
Lordship, I am for the insurance company.
For the claimant or the
I am
appellant?
for the
Appellant.
applicant.
Yes. Admitted.
It is admitted, Lordship.
Admitted. Deposited the amount.
No. There is
So?
no direction is there, Lordship.
No direction. You wanted to prepare the requisite paper book. Printed type. Where is the paper book?
Paper book already submitted.
Paper.
They are not appearing at this stage.
They're not appearing. Who? Claimants.
Claimant.
Have you served the notice?
Paper book not, memo of appeal and not served. My Lordship, can you give the instruction to serve the paper book?
Where they are residing?
Lordship,
Where they are residing? Where they are residing?
we are
Which-
deciding.
What is the address?
Address.
Chakchaka,
Chaka district, Kujbihar.
Kuch Bihar. Two paper book?
Two paper because they are not appearing, so I am
Keep with
fine.
you. It is the original.
Original.
Record and order. The appellant has filed an appeal. Appellant has filed paper book. Let the same be cut with the report. The appellant has filed affidavit of service. But it is found that the service could not be affected. Now delivered,
Delivered.
it is found that the item has been delivered to the respondents / opposite party, but none appears on behalf of the opposite party. Accordingly, the petition is directed to again inform the next date of hearing the appeal to the opposite parties and to file a fresh affidavit of service on the returnable date. It is made clear that on the returnable date, if none appears on behalf of the opposite parties, this appeal will be taken up hearing in their absence. This is the matter on.
It will take 7 days, Lordship. Minimum 7 days. See the.
Let the matter appear before, on the second day of the next circuit bench.
Lordship.
On indulgence, my lord, that citation is of May 12, 2026. The cause title is Mahinder for Taylor versus Arun and others. Civil appeal number I'm not getting, my lord.
Mahinder Kaur versus?
Justice Bishnoi.
Mahinder Kaur versus?
My lord.
Mahinder Kaur versus? Oriental.
No, not Oriental, it's written others. I think it's
Okay. Mahinder Kaur.
my lord.
That is the 5th December. 5th December.
May,
12th May
12th May, 2026.
26. 12th May 26.
Yes. Just 2 days before.
Okay.
3 days before.
Okay. Next. 19.
My lord, I am on behalf of the appellant. The
Yeah, yeah,
previous occasion, one direction was given
Huh?
to deposit the postal cost.
What?
My lord, the opposite party not appeared.
You are appearing for whom?
I am appeared for the petitioner.
Who is the petitioner?
My lord, I am the
Claimant.
petitioner. Claimant, my lord.
Okay. And who is for the opposite party?
Bhutan
Divisional
Insurance
manager, Royal Insurance.
Company, Royal Insurance Company.
Yes. So,
They received but not appeared.
where is the affidavit of service?
My lord, I have submitted in the previous occasion. After that, there was direction. There was a
As
direction
desired by the
to
Honorable Court ordered dated so postal requisites regarding the service of notice of appeal upon the respondent only have been issued. Where is the receipt? Where is the track report?
my lord, I have submitted in department. Lastly, I have to submit another. I have also submit the paperwork also.
Item delivered. The same one. No, it is another one.
My lord.
The same thing. Yes. Yes, what is the where is the award?
My lord, award is page 7, my lord.
Page?
Page 7, my lord.
Page 7.
My lord, notional income was taken.
Where is the page 7?
Page
Paper
7,
book?
Paper book, my lord.
There's no page in the paper book. How you have prepared and who has accepted this paper book? There's no page number. Nine to 11. Where is the award? Then how you have prepared the this paper book? আমার অফিসে পাঠিয়ে দিই আমারটা অফিসে পাঠিয়ে দিই অফিসে भेज दो ये को बोलो दे निकालो सुप्रीम कोर्ट से
Expert order, my lord.
There also they are not appeared.
No,
Not appeared.
not appear.
Annual income 55,500 into 12. What you are, what is your,
My lord, my PR is the national income will be at least 6,000, my lord. There
Why?
are many citation, 9,000, my lord. I have cited 2 citation.
how you prove the income?
The
What was your occupation?
occupation was driver, my lord.
Driver
Drive,
of the private vehicle.
private vehicle.
So you are not examine any person.
My lord, I examined the owner of the owner of the driver as a PW2. After the tribunal not consider interest, my lord.
This judgment is against you.
My lord,
You are relying this judgment.
yes, my lord.
Can you come to the page number 6, paragraph 6? You're not having the copy.
Now, my lord, I have.
See paragraph 6. What type of the practice you persons are doing before the High Court? Read the paragraph 6.
Discuss considering that was unspeak person.
You. So what is?
My
So
lord,
before placing the order, you could have been.
my
Go
lord,
to
another suggestion I have.
which judgment?
My lord, I submitted another judgment.
Which paragraph?
My lord, I
Take this for copy. This one. Which paragraph you are relying upon? This is the way your persons are citing the judgment. Is going on in the circuit bench.
my lord, paragraph number 5, my lord.
उसी को दो है. Where is your evidence? Where is your evidence? What you are working and you are getting the payment? Who has adduced the evidence? Who is the claimant here?
My lord, claimant mother.
Mother, only mother.
Only mother, my lord.
He was unmarried.
Unmarried, my lord.
Where is the evidence?
Not evidence.
What evidence you led?
My lord, page 25, my lord.
There's no page here. Show me the
Copy number 2, my lord.
লোয়ার ক্রেডিট রেকর্ড আছে কি? লোয়ার ক্রেডিট রেকর্ড আছে?
আচ্ছা আচ্ছা
तो अपना पास क्यों रखो? ये दिन चलता लोअर कोर्ट रिकॉर्ड अपना पास है। How many witness you alert?
Witness, two witness, my lord.
Who is he? Pushpapati Jaswal? Who
My
is
lord,
she?
My lord, the owner of the deceased.
Who is the complainant? Claimant?
Claimant is Bokul Bala.
She has not examined. Where is her evidence? Yes, where is the wrong? Kindly come to the exhibit 13. Exhibit 13.
Salaries,
Exhibit 13.
my lord.
What? This is a certificate produced by you? Huh? 5,500 then?
My lord. My lord, are taken national income, my lord.
What? Sir, you have admitted your case of 5,500 by producing the witness, Pashupati Jaswal, as a witness, who is the owner of the tractor, agency.
My lord.
So,
My lord, my lord, interest, my lord.
what is the interest?
Interest.
6%.
Interest.
What remains further?
My lord, interest was conditionally given, my lord.
What condition? Where is the interest?
Interest given conditionally within 2 months. After that, it will be the 9%, my lord.
Considering the record census and so. Within 2 months from date passing of the order, failing with, we will liable to pay interest. Okay.
Conditionally, my lord.
The petition, the appellant has filed the present appeal, being aggrieved and dissatisfied with the award passed by the London Motor Accident Claims Tribunal, Fast Track Court, First Jalpaiguri in MACC number 22 of 2013, dated 16th of March 2023, by directing the Royal Insurance Corporation of Bhutan Limited to pay sum of rupees 9,01,600 to the petitioner to the claimant within 2 months from the date of passing of the award, failing which the opposite party number 2 will be liable to pay interest at the rate of 9% per annum over the awarded amount from the date of filing of the application till recovery of the award. Full stop. The petitioner has, the appellant slash claimant has filed the present appeal only on the ground that the learned tribunal has considered the monthly income of the deceased as rupees 5,500 per month instead of rupees 6,000. 6,000
My lord.
instead of rupees 6,000. Full stop. He has relied upon the judgment, relied upon the unreported judgment passed by the coordinate bench of this court in FMAT number FMAT within bracket MV 42 of 2024 within bracket Sarathi Burman versus Reliance General Insurance Company Limited and another, dated 23rd of August 2024, and submit that in the said case the honorable court and the coordinate bench of this court has passed an order for an award of considering the notional income of rupees 6,000. The counsel for the appellant slash claimant has further relied upon the judgment passed by the judgment passed in civil appeal number passed in SLP within bracket C number 350 and civil appeal number 4310-4311 of 2023 within bracket arising out of SLP within bracket C number 3857-3858 of 2020 within bracket Jaya Rani and another versus the manager Bajaj Alliance General Insurance Company Limited and another, and submit that in the said case the Honorable Supreme Court has considered the monthly income of rupees 9,000 per month, and after deducting per month. But in the present case, the learned tribunal has considered the monthly income of rupees 5,500. He further agreed with the award on the, and he further agreed with the interest awarded by the learned tribunal. He submitted that the learned tribunal has passed the has awarded the interest with the condition that within the period of 2 months from the date of passing of the award, if the OP number 2 will not pay the awarded amount of rupees 9,01,600, the insurance company will be liable to pay interest at the rate of 9% per annum over the awarded money from the date of filing of the application. Full. Had the learned counsel for the petitioner peruse the materials on record. The two issues has been raised by the petitioner appellant in the present application. The first contention of the appellant that the learned tribunal has considered the monthly income of rupees 5,500 instead of rupees 6,000. The petitioner has examined as per the case of the petitioner, the deceased was working as driver. He was examined as PW?
PW2, my lord.
Huh?
PW2, my lord.
Driver. Where is the evidence? Working fine, the judgment, evidence. Where is the evidence of PW2?
My lord, after claim petition after.
क्या बोला?
After
driver with the PW2, with the PW. The PW2 was, the PW2 namely Pushupati Jaiswal, in his evidence has stated that Ratanlal Mandal, he was the deceased. Ratanlal Mandal, the deceased of the instant case, was the helper of the driver of the vehicle bearing registration number WB71 capital A/2634. He died on motor accident and she paid him 6,000 per month as salary along with rupees 1,150 per day for fooding. He has issued the certificate which is marked as Exhibit 13. Exhibit 13 shows that the Exhibit 13 reads as follows. Page 60. Okay. From the Exhibit 13, it finds that the PW2 has issued the certificate wherein it is certified that the deceased was lastly drawn the monthly salary of rupees 5,500 only per month, excluding ration money payable to him on account of his ration money. Though ration money, as he used to pay 150 per day. The evidence of PW2 and the document being Exhibit 13 are contradictory. In the evidence, the PW2 stated that he has paid rupees 6,000 per month as monthly salary along with rupees 150 per day for fooding. In the certificate, it is mentioned that he lastly has drawn the salary of rupees 5,500. 5,500. And that's full stop. It is settled law, the documentary evidence is prevail over the oral evidence. In the present case, the documentary evidence shows that the deceased has drawn the salary of rupees 5,500 and lastly drawn the salary of rupees 5,500, not rupees 6,000. And as such, the last payment is to be taken. The monthly payment of the deceased is to be taken as rupees 5,500. But in the certificate as well as in the evidence, the PW2 has stated that the PW2 also used to pay rupees 150 per day. Thus, per day. If 150 rupees is taken into consideration into per day, so it will come rupees. How much it will come?
Oh, my lord, it is ration, my lord. This is ration. Another. 500, 5,000 and used to pay
only per day.
Per day.
So this is total. Calculation go on. 1,150 into 30. 4,500. How it will come?
My lord, it is ration money per day.
On account of the said
And, my lord, there is and I used to pay 500 per day.
150, no
50.
100, 500, no.
100
Ration money per day.
per day.
So,
My lord, and there is and
so that's why 150. How much it will come?
4,000.
So
Another
correct. So that's why I'm asking.
Another 4,000.
Full stop. क्या बोला?
4,500.
Per day, it will come rupees 4,500 per month. ठीक है तो 4,500 per month. The learned tribunal, while calculating the amount, while awarding the compensation, has only considered rupees 5,500 but has not considered the rupees 150 per day. Per day. If the 150 rupees per day is to be taken into consideration, comma, it will come, the monthly income will come rupees 10,000. 10,000. 10,000. Full stop. As regard the interest, 10,000. Full stop. In view of the above, this court find that the learned tribunal, while taking into consideration of the annual income of the deceased, failed to consider the evidence of the PW2 as well as the exhibit 13 issued by the PW2, wherein it is categorically mentioned that the PW2 used to pay 115 per day in addition to the monthly salary of rupees 5,500. Thus, the total income of the monthly and the total income of the deceased would come rupees 10,000 per month. Per month. In view of the above, the full stop. In view of the above, the award passed by the learned tribunal dated 16 March 2023 is modified as follows, semicolon. Annual income of rupees 10,000 into 12 equal to 1,20,000. Calculate. Take the full stop. The half of the annual income, how it is to be deducted, 1/3 is to be deducted.
My lord, I have, I have written in.
It is to be deducted as a 40%.
That is half.
Half. Okay. Yeah.
My
The
lord, some
permanent
citation- My
permanent
lord, some
expenses.
citation it is 1/3, my lord.
Yes.
Some citation, it was considered
permanent-
1/3, my lord.
The personal expenses of 50%, the हम अभी बोला ठीक है क्या बोला the personal expenses of 50% is to be deducted from the annual income, so it will come rupees 60,000 है ना 120 था ना 60,000. The multiplier is to be taken into consideration as 18. Accordingly, 60,000 into 18 equal to rupees 60,000 into 18 equal to so and so, so and so. Full stop. Future prospect of 40% is to be taken into consideration, which come to rupees so and so, so and so. Full stop. The consorium, funeral expenses and the loss of law is to be taken into consideration as 70,000. Love and affection, considers to 70,000. Hence, the total compensation would come rupees so and so, so and so. Full stop. In view of the above, the respondent number 2,
My lord.
Respondent number 2, namely
My lord, 1.
the respondent number 2, namely Divisional Manager of Royal Insurance Corporation Limited of Bhutan, Corporation of Bhutan Limited, is directed to pay rupees so and so, so and so, so and so, so and so, along with interest at the rate of 9% per annum from the date of application. That is which date you file? From the date of application, that is from from 8 January 2013 till the realization of the total amount, till the payment of the awarded amount. Finished. The FMAT within bracket NV8 of 2025 is disposed of with the above modification.
My lord, one indulgence, give a direction to pay within 2 months.
Interest is there. That's why the tribunal has passed the award. 2 months.
Get to my lord.
Next.
20. Lordship, and for the insurance company. I'm
Yes.
not the affiliate.
इसको तो चैम्बर में भेजो. Yes,
I am for the insurance company.
you are the appellant.
No.
Who is the appellant?
I have not received any documents. I'm
Appellant
just
is
in-
not there, not today. Record order, record. None appears on behalf of the appellant. Let the matter appear tomorrow.
Let-
Next.
21.
Lordship, I am for the claimant here. Insurance is the appellant.
Who is the appellant?
Appellant is Miss Singh, Supriya Sinha. Supriya Singh.
Yes.
Lordship, I have the applicant.
Yes.
Lordship, though in this case, paper book has not been filed, Lordship. So shall I move from the?
Why you not file the paper book?
Because there is no direction.
No direction. LCR has come. Oh, Dada. LCR has come. Yes. Paper book. Have you deposited the amount?
Yes, Lordship.
How much amount?
Long back, Lordship.
25,000 only.
25,000.
Statutory amount you have deposited. Where is the awarded amount? What is the awarded amount?
One of the 3,58,000. Lordship. 3,54,000. 3,54,000.
3,54,000.
Lordship.
When you deposited?
I have to, 3,54,000, Lordship, that I have to check, Lordship, because this case was filed long back,
24.
20.
June 24.
I have filed the deposited amount.
Statutory you have deposited. Statutory amount of 25 you have deposited.
Then I have filed.
By which order? I did
If
not
there is
find.
a stay order, Lordship, then. I have
Stay is there.
Yes, Lordship.
Copy of the award, received 25,000.
Yeah. As
Kindly
soon as
stay
she filed the statutory amount, stay has been granted.
Yes, statutory amount, the stay has been.
Stay has been granted, but so but the claim amount has not been deposited.
Yes, it is. There is a report. Received 25,000 on 10th of March, but no, 3,54,000 not been deposited. Not yet been deposited.
May I check the record once?
It is a record.
Is there any stay, Lordship, stay order,
Stay is granted. Stay.
conditional
Stay
stay?
petition grant.
Let the delay be 17-day condone. Award amount may be deposited within 15 days from
Yes,
date if
Lordship,
not
I have
deposited.
already filed the awarded amount, Lordship. Lordship, kindly keep it on Monday, Lordship. I will produce the challan, Lordship.
The
Lordship, actually, if paper is actually required, can I?
I have no problem. Both the parties are
If
ready.
you-
This
you-
court will
my
go to-
my sister is
Fix any date next week for the final hearing.
Monday, Tuesday, Lordship.
What is the ground of challenging?
Lordship,
Challenging.
there is a contradiction from the FIR and the charge sheet, Lordship.
It's a not a
FIR.
criminal trial.
Yes, Lordship.
Out of accident, 3 persons
Not
already
a
been.
criminal trial. Admitting the accident,
Yes.
vehicle involved.
accident not by the vehicle lordship. They say that the
Contributing negligence
contributed-
is the 166 or 163?
163A.
Then
163A, Lordship.
the vehicle involved in this case is the truck. They are all the traveling in the truck. Truck is a commercial vehicle. So any person traveling in the truck is not, the insurance company in that case not liable to pay any
my lord,
commercial.
latest judgment.
My lord,
Yesterday,
my lord,
Supreme Court.
Pay and
He
recovery
was in the cabin. It was a transfer. It was not a transport vehicle entitled to get.
The truck is a commercial vehicle.
But
How can a person
out of-
travel in a truck lordship?
Why you are loaded? Why you are allowed?
Lordship, out of the
Why you are
5%,
allowed?
out of 5%, 3% already been she.
Why you
Even-
are allowed to travel?
Then lordship, pay and recovery order at least lordship.
Huh?
Pay and recovery lordship.
Okay, let us, the department is directed to submit report whether the claimant has deposited the awarded amount along with the interest or not. Let the report be filed by 19th May, list the matter on 19th.
90, Lordship. Lordship, can you pass on the paper books is required?
Police, the counsel for the party submit that the paper is not required and both the party will argue the matter without the paper book. Accordingly, filing of the paper book is dispensed with. List, yes, let the matter appear on 19th for hearing.
Deep.
Next.
22 to 23.
Lordship, in 23, I am on behalf of the appellant, and the claimant has also filed separate appeal, not cross appeal.
Both.
Lordship, there are two appeals, Lordship. So my point actually, on the last occasion, it was admitted, Lordship, and necessary directions were given, Lordship. And accordingly, LCR has already been called for, and that is available in the record, Lordship. Now the question, there are only two grounds of my appeal, Lordship. One,
For the insurance.
no, I'm not actually for the petitioner, Lordship.
And I am
For the petitioner, I have
the
filed
insurance
what
company.
let me
I have also
complete.
filed the appeal. My appeal is pending for admission. Let it be admitted since they have appeared. Item number 20.
Lordship, already record has come, so let it be formally admitted, Lordship, and kindly keep it in the next week, Lordship, so that it can be disposed of, Lordship.
My appeal is also required to be admitted.
Your appeal is not
No,
admitted?
no.
No. Such being the person desirable instant appeal, I go.
আরে কজ লিস্টটা কোথায়?
Having heard the land counsel for the appellants, the appeal is admitted.
That is their appeal. Our admit.
Appeal number 5.
Lordship, my appeal number is FMA 48.
Appeal number 5. Appeal number 5 is admitted. Where is the appeal number 5?
It is probably their FMA number 5. It was denumbered as FMA number, no 48.
FMA 48. 48.
My appeal
48 is mine.
The FMA 5 is been given a renumbered as
48
and
of
not-
2025.
48.
Lordship, there are two appeals. There is no.
Just a minute. 48 is the FMA 5.
By the
So,
claimant.
48 of the claimant. That has been admitted.
Lordship.
And
That is admitted
Lordship.
by an order dated 1st of April 2025. By an order dated 1st April 2025, instead appeal has been prepared challenging the judgment passed by the motor accident awarded 4,82,000 with interest, rendered appearing for the appellant submitted the amendment of the provision section so having heard the appearing for the appellant direction notice inapplicable. Yes,
I have also prepared the paper book, Lordship, and
paper book is ready.
Yes, Lordship.
So
My
it
appeal is
will take
ready.
we have also
The
required to
same
file
thing,
the
Lordship.
direction. Our appeal may be kindly
Which
admitted.
appeal? Appeal number
Our appeal
FMAT
is, 55 of 2023.
55 2020.
Yes, there is
You
a
are an
10
insurance
appeal-
company. Then
insurance
you have to deposit the amount.
No, we have deposited statutory amount, but there is a delay. That
You have
delay-
deposited the statutory amount.
Yes.
When?
On
No amount has been deposited.
Yes.
Please furnish the report whether the statutory amount has been deposited or
Yes, sir.
not. No amount has been deposited.
On-
There is a report.
They are not giving it. We are carrying the challan
When you deposited.
on long back on 20
Date.
9.
There is a
First, September 23.
September 20, yes, it is August 23.
Yes. You have deputy.
What is the challan number? Give the
The
challan number, give the copy of the challan.
105.
The claimants have preferred an appeal being FMA 48 of 2025, which has been admitted by this court. By an order dated 1st of April 2025. The appellant has filed the paperwork, let the same be kept with the record. The insurance company has filed the cross appeal being FMAT MB 55 of 2023. It is fine from the note sheet that till 30th of August 2023, the
It is separate appeal. Not
cross.
Not court.
Not cross.
No.
The insurance company has preferred an appeal being FMAT MB 55 2023. In the said appeal, there is a note that the note dated 30th August 2023 that the insurance company has not deposited the statutory amount of rupees 25,000. The petitioner has handed over the original copy of the challan number 105. Challan number 105 dated 11th of September 2023, wherein it is found that the insurance company has deposited the statutory amount of rupees 25,000. Full stop. The department is directed to verify the same and to submit the report whether the insurance company has had deposited the statutory amount of rupees 25,000. As in FMA 48 of 2025, the claimants have already filed the paper book and thus filed the paper. Full stop. The claimant has already preferred an appeal and the paper book has been filed. Accordingly, the appeal filed by the insurance company limited being FMAT MV 55 2023 is admitted. Full stop. The claimants have already filed the paper book in FMAT number 48 of 2025 within bracket FMAT MV 5 of 2025. Accordingly, filing of the paper book in FMAT MV 55 2023 dispensed with.
Yes, dispensed with.
We have also record to file because our memo will be different.
Memo is already there. Paper book is
Memo is
memo
there.
is not in the record.
Memo is there.
Memo is there, but we file paper book.
Why?
Same. Unnecessary wasting time, Lordship.
Why? What is the necessity you want? You tell what document you are not disclosed in the appeal? Why you want to kill the time?
The date of filing we will file.
Lordship, kindly keep it in one Monday, Lordship.
Let the matter appear on 19th May.
Lordship, grateful, Lordship.
Let both the appeal be, both the FMAT will be fixed on 19th. Next, call the password matters. Chalan to, it's a copy there. Give the copy. Chalan copy. Give today itself because it has to be verified. Yes, call the first matter. Password.
Passed over matters. Item number 3.
My lord, I am for the petitioner, my lord. Petitioner defendant. Today we have filed, leave was asked for, my lord. There was for filing of the documents. So today it has been solemnly affirmed and we are filing the documents, my lord. And we'll be serving a copy during the course of the day to the opposite party.
Then my lord, today accommodation, because I am appearing on behalf of the opposite party, my lord.
Jointly requested appearing. Yes, what you have filed?
I filed the agreement, my lord. And the certain correspondences are there, the notices and the replies.
What is this? The CO?
CO, my lord.
And what is the CAN?
CAN is for?
CAN 1?
Oh, that was my lord, that was for
Delay
there was
of
a misconception. It's required because this is 227 application, my lord. So it's a supervisory jurisdiction, my lord. So section 5 not required. My lord can allow.
So why you have filed the supplementary?
Supplementary, I filed the documents, my lord.
Okay.
We have taken the leave also at the time of filing this year.
No, there's not such leave. Which order? By which order?
It's
Only
in
one
the,
order is there.
it's in the, I'll just.
The only one order is there on
No, my lord,
27th of
it's in
April.
the petition, page number,
Acha, in the application you crave leave.
my lord. Page 5 of the main application.
Record an order. The petitioner has filed supplementary affidavit disclosing certain documents. I have served the copy.
My lord, they are not present.
Let the
within
same be
course
kept with
of
the
debate.
record. The petition is directed to serve the copy of the supplementary affidavit to the learned counsel for the opposite party in course of the day. Full stop. List the matter on 20th May 2026.
Tuesday, my lord, Tuesday.
20th May 2026.
20th.
Yes, next. 4.
Grateful, my lord.
Lordship.
Budhbar.
Item number 4, I am appearing on behalf of the petitioner defendant. My lord,
Yes.
yes, my lord. My lord, on the last
Who has,
occasion,
who has prepared this revisional application?
yes, my lord, I have prepared the revisional application.
You are the revision. You are the petitioner.
I am the petitioner defendant. My lord, my order
Okay.
7 rule 11 was rejected.
Yes.
That is why, my lord, this civil division application has been preferred. Now, my lord, the
Yes.
important part of the civil divisional application is the documents given to the court by the plaintiff along with the claim is not with me. I believe it is with my learned senior friend who is appearing for the plaintiffs in the suit in the court below, my lord. So, I need those documents for showing your lordship that actually the plaint is not maintainable at all and the plaint is absolutely vexatious, my lord. So for that, my lord, I require the documents, my lord. I believe that my counterpart in the yes, my lord.
Sir. You have filed an application under Order 7 Rule 11.
My lord.
After going to the plaint and the document,
my lord,
you have argued the matter before the trial court,
my lord,
and your application is rejected.
My
Now, in the revisional application, what document you required?
My
Because
lord,
this Order 7 Rule 11 based only on the basis of the plaint.
Plaint and the documents, my lord. Subject to correction, plaint and the documents filed with the plaint. So those documents which were filed with the plaint, those documents are not with me. Because, my lord, there has been a subsequent change in the advocates appearing in the court below.
Might
in
be
the trial court.
changed.
My lord,
This court will not going to pass any adjourn the matter if you want to argue. Otherwise, I
my
will
lord,
decide the
today-
matter on merits. Sir. Sorry.
Today, my lord,
I know how the advocates wanted to adjourn, take the adjournment.
No,
So
my lord,
morning your junior has passed prayed for that his senior is in Calcutta. Once I have fixed the matter, now you are taking another plea that
My
the
lord,
document is not. You have filed an application under 7 Rule 11.
Yes, my lord.
Your application, now you cannot take the defense that the document is not with you.
I
It
am
is
not-
your
I
application.
am not, my lord.
Sir,
I bow
yes.
down.
Who's
I
for
bow
the
down.
defendant?
I bow down.
Yes, what?
My lord, just one
Lordship.
minute.
Yes, what?
Give me some time. Give
Yes,
me
where is
some
the
time.
Order 7 Rule 11 application?
Give me some time.
Lordship,
My lord, I
order,
don't
sir.
even have the brief with
Sorry.
me, my lord. My lord,
Lordship,
Now, if
order
you're not
keep-
ready, why you're appearing? Why you're
my lord,
appearing?
kindly keeps it on Monday or Tuesday. my
This
lord,
court is not
as-
having further time. 2
Lordship-
days already wasted.
My lord,
Now every matter cannot be fixed tomorrow, day after
My lord-
tomorrow. If you want to argue, then I will take the matter on
my lord,
merit.
I don't have the
At
brief
page
with me,
41,
my
Lordship.
lord.
Yes,
My
tell
lord,
me.
kindly
Lordship-
appear for today, my lord.
Sorry,
I-
sorry,
Your
Mr.
lordship
Mr.
wants, I
Munshi,
can
sorry.
come tomorrow, my lord. I can
No,
come
no,
tomorrow.
no. But,
I can appear
sorry,
virtually.
the matter was listed 2 days before the continuous before the court number 1. You could have been get ready. Now
I-
today is the 3rd day.
I
So you are
bow
not
down, my
ready.
lord.
What the court
I
will
bow
do?
down. I
Sorry.
bow down. I
And you cannot change. You cannot change the stand. Morning your junior has taken the
No,
stand
my lord,
that your senior
I
is not
certainly-
well.
My lord, I certainly cannot take the change stands, my lord.
So why
I-
you accepted the
No, no, no.
accepted the brief when you are not having all the document? Why
Lordship-
you accepted the brief?
kindly appreciate this, my lord. Kindly
Sorry,
appreciate
sorry,
this.
sir, Mr.
My lord,
Munshi, sorry.
Either, my lord, Monday, as your lordship, whenever, but
No,
kindly
no,
makes it.
I already fixed the Monday, Tuesday because Monday, like next week is the only 4
Lord-
working day, 5 working day.
Very well, my lord.
The
Do
court
not
cannot take the burden
My lord,
all on the next week.
absolutely not, my lord. I would also not tell the court to take the burden. My lord, kindly keeps it tomorrow, my lord. Tomorrow I'll be ready.
As per the
Tomorrow,
prayer made by the
Lordship, kindly
council for
make
the
it day
petition,
after
let the matter
tomorrow.
appear tomorrow as at the top as contested application.
so grateful, so grateful.
Next. 5.
ये 4 number edition.
19/5, my lord, I appeal for the opposite party.
Yeah, so is for the petitioner.
So I do not.
Who is for the petitioner? What is the order? Where is the order?
My lord, the order is at the end. My lord. It have to be at
Order
the end, my
39
lord.
rule 7.
Yes, my lord.
Yes.
Order 39, rule 7, my lord, the application was allowed, my lord.
Who has filed the application? Defendant or plaintiff?
Plaintiff.
Plaintiff, you are for the
I am
defendant.
for the plaintiff, my
So
lord.
how you are agreed with that order?
I am not agreed, my lord. The order has been passed in my favor, my lord.
You are the plaintiff.
I am the plaintiff.
Hmm.
Order 39, rule 7 was, the application was filed by me, my lord,
Hmm.
and the application was allowed.
Where is the 37 rule 7 application?
My lord, that's in page number 42.
42.
Yes. It's a case of an illegal construction, my lord.
Just a minute. An application order 39 rule 7. Where is the question?
My lord, that at the time
It
of
is the
filing
place
of
for
the
landlord to please to pass an order of
Paragraph
permanent
4,
reader to take photographs of the suitable property. For the taking photographs of suitable property, the commission is required.
no, that has not been given, my lord. The order.
Whether
as-
the defendant number 1 is still carrying on with the illegal construction and upon her
An
holding.
inspection order has been given, my lord.
Whether the defendant number 1 is still carrying on with the illegal construction
Illegal
and
construction.
upon her holding
Case of an illegal construction.
detailed and describe the suitable property. The total storage constructed the plaintiff and upon the suitable
To
property.
preserve the nature and character of the suit property, my lord, the application has been filed, my lord. It was a G+5 storied building, my lord, and they have constructed a G+7 storied building.
Hmm.
In spite of there being an injunction order of the same, my lord.
Hmm.
So there has been a violation of the injunction order, hence, my lord, this order was passed.
Where is the injunction order?
That it's the injunction order.
Hmm.
The injunction order is annexed in page number 26.
Page number
26 is the operative part, my lord.
26.
26.
Yes.
The defendant number 1 is hereby restrained from carrying on any illegal construction.
Where is that?
That page number 26, my lord.
The defendant number 1 is restrained from carrying any illegal construction upon the
G+5 structure.
G+5 structure over B schedule till the next date.
And that has been continued.
Till the next date.
Right.
So then what has happened? Whether this order was absolute, made absolute. What has happened after this?
Thereafter, it was made absolute.
By which order?
My lord, they preferred an appeal against that, my lord.
No, no.
That's-
Where is the order? Order 39 rule 7 today speaks for order in connection with the petition 1 filed by the defendant for
They-
and filing WS. Defendant filed a petition.
It's going on, my lord. Usually, a prayer is made, my lord, to continue the injunction order, and it is going on, my lord. That injunction order is still enforced, my lord. And in meantime, this order 39 rule 7 has been given, my lord. They are aggrieved. Why, my lord? Because earlier order 39 rule 7 application was filed.
Vacating the ex parte injunction details passed by the learned to consider and rejected. Defendant's application was rejected. You're not ready with the brief.
My lord,
Come to the 28.
yes,
Their vacating application was rejected.
rejected, my lord.
Then what has happened?
Vacating application
Then they
was
prepared an appeal
appeal, my lord.
before the district judge.
Yes,
Misappeal.
Yes, my lord.
So what has happened in the misappeal?
It said, my lord, it's a the order was the
Yeah,
order
appeal the
passed-
same is dismissed.
affirmed, my lord. The civil judge
The same is dismissed. The order passed and civil judge and hereby affirmed. The director to
Affirmed the
dispose
order.
of the suit properly within a 6 months.
yes, sir.
Yes. Then
Then one order 39 rule 7 application was filed by the
Then you
plaintiff.
have filed.
I know.
You
First
filed
one
the
application was filed, my lord, on 16/4/2024, whereby the application was,
But one thing you tell me,
my lord.
the first order which you're relying upon, that is the ad interim order.
Yes, my lord.
Correct.
Yes,
That
my
is the ad interim order.
My lord.
So they filed an application for vacating that has not been vacated.
Yes, my lord.
They preferred an appeal.
Yes, my lord.
In the appeal, the appellate court has affirmed that order.
Yes, my lord.
But what has happened to the ad interim? Thereafter, what it was made absolute.
My lord, I do not know. I did not take instruction in that regard, my lord.
Then what has happened? Order 39 rule 7.
Order 39 rule 7.
You filed.
I filed.
What is your
This
allegation?
was rejected, my lord.
In spite of the court injunction, or defendant is still continuing with the illegal construction of her holding fully detailed the Schedule B.
This
The defendant does not have any building plan for the construction of the second construction of undertaken holding detail. Yes. Then
this application was rejected. That's in page number 38.
now
But
this
it was not
application-
rejected on merit.
This application was rejected.
Yes, it was
Where
not
is that?
rejected. Page number 38.
Page number 38.
Because the court found the application
This content-
confusing.
content of plaintiff from need commission can be solved provoking itna. 38.
It is a, yes, fine. The operative part is in page number 40.
40.
Yes.
Petition
The above
rejected
prayer
on
portion of the
contest
plaintiff.
with rupees cost of rupees 1000.
It
So
says
your
that,
application was rejected.
yes, because it was confusing application, my lord. The above prayer portion is, as mentioned here, is of the instant petition is contradictory to its plain and confusing as to what the plaintiff intends to plead, and hence it was rejected. It was not heard on merit. So subsequently, there was another application filed, and which was allowed, my lord.
Yes. Then
The-
you filed again,
Again. And this was allowed.
and this was allowed.
This was allowed, and they are aggrieved by the same.
Then they have agreed with this order.
This order, man,
Okay. Now this is the impugn order.
is there anything?
Where is the impugn order?
It starts from page number 48. They've annexed it.
Yes. Remain in the outside. Yes, record and remain in the outside. The petitioner has filed the present revisional application being CO 53 of 2026, challenging the order passed by the Learned Civil Judge Senior Division Darjeeling, dated Darjeeling by order number 31 dated 2nd February 2026, wherein the Learned Civil Judge Senior Division has allowed the application filed by the plaintiff for appointment of commissioner under order 39 rule 7 of the Code of Civil Procedure and directed the advocate commissioner to hold the local inspection of the suit scheduled property after due service of notice to the parties or their respective learned advocate, and will videograph the suit scheduled property and will take still photographs from different angles and meet up the questions as mentioned in the petition and file his report before the learned court. Counsel for the counsel for the petitioner and the plaintiff has filed the suit against the defendants for permanent injunction, restraining the defendant number 1 from making any illegal construction in violation of the Municipal Act rules and bylaws, as well as the mandatory injunction, as well as prayed for decree for mandatory injunction against the defendant number 2 to dismantle the illegal structure constructed by the defendant number 1 in violation of the Municipal Acts and rules and bylaws in the Schedule B property. The At the time of filing of the suit, the plaintiff has also filed an application under Order 39, Rule 1 and 2 of the CPC for grant of ad interim injunction. By an order dated, which date? The interim order?
Order dated, the dated 15/12/2020.
By an order dated, where is the date?
It's in page number 26, my lord. It's
26,
not clear actually. 15/12/2023.
15/12/2023. The London Civil Judge Senior Division had passed an interim order restraining the defendant from carrying out any illegal construction in the in and upon G+5 structure over B scheduled property. Full stop. After the order passed by the London judge, the defendant has taken out an application under Order 39, Rule 7 of the CPC for Rule 7 or Rule 4?
Order 39, Rule 7.
How the 7? 7 is a variation.
Yes, my lord.
7 is the appointment of commissioner.
Yes, my lord.
So, but the defendant, kindly come to the page 27.
Page 27.
Wait, huh? No problem, no problem. Yes, argue. I am giving the opportunity, argue.
That is a vacating application order, my lord.
But 39
Page
Rule 7.
27.
39 Rule 7.
No, they have might have been written
kya
wrongly,
bola?
my lord.
The defendant has filed an application for vacating the interim order passed by the Learned Judge dated 15 December 2023. By an order dated 14th May 2024, the Learned Judge has rejected the application filed by the defendant for vacating the interim order. Being agreed with the said order, the defendant has preferred a misappeal before the Learned District Judge, being misappeal number 59 of 2024. The Learned District Judge has also dismissed the misappeal on 20th September 2024 by affirming the order passed by the Learned Civil Judge Senior Division with the direction to the Learned Judge to dispose of the suit preferably within a period of 6 months without granting any unnecessary adjournment. Full stop. Subsequently, the plaintiff has filed an application under Order 39 Rule 7 of the CPC for appointment of commissioner. The defendant has filed objection, and after hearing the parties, objection to the said application, and after hearing the parties, the Learned Civil Judge Senior Division has rejected the application filed by the plaintiff for appointment of commissioner on the ground that paragraph 7 within bracket A of the application is contradictory to its plaint and confusing as to what the plaintiff intends to plead. Full stop. The said application was dismissed with the cost of ₹1,000 against the plaintiff. Subsequent to the dismissal of the rejection of the said application, the plaintiff had again filed an application under Order 39 Rule 7 and read with Section 151 of the CPC for appointment of commissioner. The Learned Trial Court has allowed the said application, which is impugned in the present application. The plaintiff has filed the application under Order 39 Rule 7 of the CPC, read with Section 151 of the CPC, praying for appointment of commissioner on the following points. Number A, small a, to take photographs of the scheduled property, Schedule B property, capital B. B, whether the defendant number 1 is still carrying on with the illegal construction in and upon her holding, fully detailed and described in the Schedule B property. Number C, the total storage constructed by the plaintiff and in and upon the Schedule B property. Schedule B property. Full stop. Consider full stop. The application filed by the plaintiff for appointment of commissioner on the allegation that in spite of the order passed by the London trial court, the defendant defendant is still continuing with the illegal construction and has already constructed more than 7-storied building fully detailed and described in the Schedule B of the plaint. Full stop. The London trial judge, while allowing the application under order filed by the plaintiff under order 39 rule 7, has categorically come to the finding that in order to solve the issue in dispute, the court find that the inspection of the suit premises is necessary to ascertain whether any such alleged construction is made out or not. Full stop. Considered the above, this court did not find any illegality in the impugn order passed by the London trial judge by order number 31 dated 2nd February 2026. Accordingly, this court did not find any and did not accordingly CO number so and so is dismissed.
I'm grateful, my friend.
First row matter, item number 6.
Yes. Yes. For the petitioner?
Petitioner, your lordship.
Yes. Who is for the opposite party? Have you served?
Lordship, it was.
Where is the affidavit of service? Yes.
My lord, I am appearing for the petition, my lord.
Yes.
My lord, am I audible, lordship?
Yes, you are audible.
My lord, this is a by virtue of the order impugned. My lord, our recalling application has been turned down by the learned court below. My lord, what happened, my lord? My lord, the
Who is
husband.
for the opposite party?
My lord,
Nobody.
we have tried to serve, but it has come back with an endorsement, my lord, insufficient address.
So what is the address in the plaint?
My lord, the address in the plaint, my lord, we have served, my lord. If your lordship kindly comes to the plaint for a moment, I have annexed it, my lord, page 14. My lord, the same address we have served, my lord.
Page 14.
Yes, lordship. Srimati
Page 14 is nothing.
No, page 11, lordship. My lord, I stand corrected.
Page 11. Yeah.
Page 11. I'm sorry, my lord. Page 11.
Care of Shankar Pradhan. Address. No. There are two addresses.
No, my lord, the same address. My lord.
Morgang Tea Estate. Morgang Tea Estate. But you have sent to whom?
No, my lord, lordship kindly sees. My lord, it is sent to my lord.
Page 16.
Yes, page 16.
Yes. See, page 11A. What is the address?
This is the matrimonial. Lordship, on page 11, the address which is here, your lordship, it is her matrimonial home, your lordship. So she currently resides on the address which is there in page 16, your lordship.
16. Kalmajot.
Yes, your lordship.
Asia More. Alsia More.
Sushrudnagar, PS Matikara, district Darjeeling.
This is the application filed by whom? Section 24 was filed by the opposite party only.
Opposite party, your lordship.
So the same address.
Yes,
and it was returned. What is the reason?
My lord,
What is the reason?
Reason shown
No
is
such person. No such person.
No such person, your lordship.
Okay. Yes, what is the matter?
My lord, lordship may kindly have a look to my lord. Our application, my lord, for a moment.
Video kya? What has happened to your video?
My lord,
Why you're off the camera?
my lord, my lord, I have on, my lord, from video it is showing it is on, but my lord, I do not know why it's showing, my lord.
Yes. Where is our impugn order?
My lord, lordship may kindly have a look to. My lord, I am sorry, my lord. Now, my lord.
Yes, where's the impugn order?
Yes, my lord, the last certified copy your lordship kindly sees. My lord, the impugned order is there.
Order 18, Rule 17.
Yes, my lord, the order 18, Rule 17 application has been turned down.
But you mentioned the order 13, Rule 17.
It is, my lord, wrong. My lord, it is a mistake on our part. It is wrongly.
What is the wrong in the order? See, your senior counsel was sick, no problem at all. You filed an application, there is no problem at all. But once you filed an application and the case is fixed for cross-examination and you're asking for the time, the adjournment application has to move before the court. The court is not a post office. Your advocate on record or the junior advocate who has filed an application, he has not moved an application before the court. What the court will do?
My lord, I understand. Your lordship may kindly have a look at page 37. Lord.
Page 37.
Yes, my lord, on 16th of April 2025, my lord, order number 45.
Correct.
Correct. Today is fixed for further cross-examination of PW1. The petitioner is with a learned advocate. A petition seeking adjournment has been filed by a learned advocate of the opposite party, but none moved such. Yes, in spite of repeated calls.
None more.
This court failed to trace out a vakalatnama executed by the opposite party in favor of the
Correct.
learned advocate who had filed such petition. Considering such,
Correct.
the seeking time stands refused. PW1 stands closed. The learned advocate for the petitioner sought for time to bring for further witness. I allow the prayer. My lord, my lord, bow down to your lordship. My lord, we couldn't move, but lordship kindly sees. My lord, the prayer ultimately.
But who has filed the application? He's not an advocate. He is not having the power. No vakalatnama. Who has filed an application? Can you see the application, page 36?
Yes,
He's not having the power before the learned court.
My lord, my lord. My lord,
Then,
it is filed by my lord one Tanushree Bormon, my lord, advocate. It is written.
but he's not. He or she is not having the power before the court. Who has filed an application, and he has not moved the application. So how the court can accept the application for adjournment?
My lord.
And what is the section 24? What is the case?
My lord, section 20.
What is the miss?
Yes, my lord, the miss case, my lord, the wife filed the miss case praying for, my lord, seeking maintenance penalty, my lord, for herself, the child, my lord, to the tune of rupees 40,000 per month. My lord, that is the case. Now, my lord, how we, my lord, try to, my lord, cross-examine on the point. If your lordship kindly comes to the written objection for once, my lord, we, my lord, try to show that she has independent income of her own. This is number one. Number two, my lord, she, my lord, voluntarily, my lord, left the matrimonial home. She, my lord, didn't participate. She was in Dubai. She was working in a private, my lord, company over there. And, my lord, she has independent income of her own. My lord, these are the few things, my lord, will just cross it. Lordship, kindly, my lord, put me on any term. My lord, kindly fix one day. My lord, I'll cross-examine her and, my lord, I'll close.
No. This type of Mr. Chakravarti, this type of the application, if today this will allow, then it will be a high court order, then will be a precedent. Your advocate not appeared. Okay, if the senior was not appeared and the court has, after moving the application, rejected, there would have been something else. The application which you have filed, the advocate is not having the power. Okay, not having the power, that also can be not look into, but the application has to move before the court. You're not moved. Sorry. Sorry, you whatever the defense, you take your defense by examining the DW, sir.
May I humbly submit one
The petitioner has filed the present divisional application being agreed and dissatisfied with the order number 45 dated 10th of February 2026 passed by the learned additional district judge fast track court Siliguri by rejecting the application filed by the petitioner under order 18 rule 17 of the Code of Civil Procedure for recalling of the petitioner PW1 for cross-examination. The respondent, the opposite party, had filed an application under section 24 of the Hindu Marriage Act, claiming maintenance, pendant flight and expenses of the proceedings. Full stop. On 16th of April 2025, the matter was fixed for cross-examination of the PW1. On the said date, the learned advocate appearing for the petitioner herein has filed an application for adjournment. But when the matter was taken up by the learned judge, none has come forward to move the application for adjournment. It is further reveals from the order that the application filed by the learned advocate was not having any power to file the application in the said case, has not having vakalatnama on behalf of the petitioner herein to file an application for adjournment. Accordingly, learned judge has rejected the application and closed the evidence of the evidence of the PW1 for cross-examination. Full stop. Learned counsel for the petitioner submit that the learned senior counsel who was appearing for the petitioner hearing before the learned additional district judge fast track court Siliguri was under medical treatment, and as such he could not appear before the learned court, and the other advocate appearing for the petitioner hearing has filed an application, but due to inadvertence he could not appear before the court for moving the application for adjournment. This court find that the petitioner had the knowledge that on 16th of April 2025 the matter was fixed for cross-examination of the PW1. If the learned advocate who supposed to cross-examine the PW1 was under medical treatment, but the other advocate who filed an application for adjournment ought to have moved the said application by appraising the learned court that the senior advocate is not well and not in a position to cross-examination. Instead of doing so, only filing an application for adjournment, none appears on behalf of the petitioner to move the said application. Full stop. Even the learned, from the order, it is found that the learned additional district judge also taken into consideration whether the application filed by the advocate for adjournment was having the wakalatam on behalf of the petitioner. On verification of the record of the miscase, it was found that no, the advocate who has filed the adjournment application for cross-examination of the PW1 was not having the power also. Considering the above, this court find that the learned additional district judge fast track court Siliguri has rightly rejected the application filed by the learned advocate who was not having the power in the said case and also even not moved the said application. Full stop. In view of the above, this court did not find any illegality in the impugn order. Full stop. CO number so dismissed.
Milord, only one humble submission. If your lordship kindly allows me, Milord, to take Milord the points, Milord, at the time of argument, Milord.
Full stop. Though by an order dated 16th April 2025, cross-examination of PW1 closed, and by an impugn order dated 10th of February 2026, the application filed by the petitioner for recalling of the PW1 for cross-examination was dismissed, but this order will not prevent the petitioner to take appropriate step before the learned court to prove his case by adducing evidence on as DW and argument.
Grateful one. Grateful. Deeply obliged.
14 বাকি হয়ে গেছে বাকি সব হয়ে গেছে yes yes 14 you are appearing.
Lordship, I am for the appellant in 14 and opposite party in the item number 15.
14 is
Appeal, counter appeal.
Affirmative 7.
Affirmative 7.
You are the appellant.
Appellant.
And you are with the?
I am for the appellant for 15 and respondent for the 14.
Okay. Yes.
Lordship, may I please?
So you are the claimant before the tribunal.
Tribunal.
Yes.
Lordship, one Purna Mitto died in a road traffic accident.
What is the ground? Where is the award?
Lordship, award is from
In the paper book.
paper book. All in the paper.
So on one paper book.
Page 25 onwards.
Page 25. The
Lordship,
166. Application number 166.
166.
So how much amount you have? 39,28,750.
Lordship, average income has been taken,
Okay.
which is not part.
Why?
One ground and another ground is Lordship enhancement of interest. And
Who are you?
default interest.
Momita Mitto.
Momita is wife and
Ah.
another next to is minor son and daughter,
Ah.
and last is mother.
Mother, son, daughter, and wife.
Yes, Lordship.
Okay. So what he was doing? What was the disease?
Lordship, he was a surveyor by profession, and
By
he
profession in private.
private, and
Yes.
he used to submit income tax regularly, and that has been marked as Exhibit 15.
Hmm.
The departmental
What-
officer was called for.
What was the last income tax return?
Lordship kindly sees page number 65. 65, next page 66.
2015, 2016.
This is the page number 66, last in the year assessment year
Page number
20.
66. 60.
66.
Yes.
Lordship, the table shows
Yes.
in the year 2015-16, in which year he died.
Hmm.
Before that year, his income was 2,97,070 rupees and tax paid 3,000.
Huh? Total tax paid 3,000.
Lordship. So the annual income had to be taken into consideration. That is 2,94,070.
Hmm.
That was not taken.
Where is your return? Where is your return? Income tax return?
Lordship, subsequent pages.
Huh?
Subsequent pages. I am showing.
When the incident was occurred?
Lordship, kindly see page number 80.
80.
80. Total income, Lordship, column number 14. Column number 14, total income 2,97,070.
97,770. This is the total income.
That is the last income, Lordship.
Taxable.
Last return submitted. Tax paid 3,000 according to the income tax authority. That is the letter issued by the income tax
So
authority.
this is annual income.
Lordship.
2,70,000. 2,70,000 per month. 2,97,000 divided by 12, what will come? ए कल के कैलकुलेटर लगते हो बे
Lordship, 24,755.
24,755.
755.
So what is the income he has taken? Where is the calculation of
Lordship,
the
I am showing. Lordship, in the judgment.
annual income? 2,45,000.
Lordship, that Lordship kindly sees.
How 2,45,000 it has been taken?
That I am showing, Lordship. That I
Page
am showing.
37. Page 37. Come to
Lordship,
page 37.
kindly see the page number 35. Page number 35, last line, Lordship.
In support of the income of the deceased, certified copy of the ITR of the deceased so has been, as per the ITR, gross income, this is was 2 lakh. Gross annual income of the deceased was 2,05,007 for the assessment to the 2,90,000, 26, 27. Yes.
And 2,97,000, that is also written.
Correct.
On perusal of these documents, this tribunal finds no reason to dispute the information given therein. Considering this document, the tribunal finds no reason to hold the average.
Average 2,45.
Actually, actually, Lordship, business was not proved.
No. Business proved or not proved. If a government servant died, what we have to prove? The last pay certificate. We are not proving the 10 years what will be the pay. The last pay certificate, what is the last pay certificate? Either 20,000, 50,000, 1 lakh, 2 lakh, 5 lakh, whatever it is. Here, 25, 2015, 2016, the income was 2,97,000. And when he died, what is the date of the death?
Actually, Lordship, income from the salary is the fixed, but income from the business is not fixed.
Correct, business, but we have to say why the ITR? Why the ITR? So last income, and if we see, kindly come to the 35, page 35, his income is not decreasing, his income is increasing. If it is decreasing, then you can say, yes, one it was at 2 lakh, one it was 1,50,000, another is 2,50,000, so that we can take average of the 3 into so and so, 2,45,000. Here the income is increasing. Once the income is increasing, so how you can take the average on that? Under which provision of law?
Lordship died on 19th October 2016.
2016. And ITR filed on April, May, March.
March.
Where is the
Page 80.
financial year? Where is that?
1516. Lordship, that is in the letter of the income tax department.
No,
Page
this
66.
This return.
Return page number 84.
1516. Assessment year 1516. 72. Assessment year 1516.
1516.
Yes.
Lordship, actually, my submission here is that there is no guarantee regarding the income from the business, and accordingly, they fail to prove any papers. to
Sir,
show that-
about the other than income tax return, that is the other than what you want to show. What business he was having?
Lordship, he was a surveyor.
He was surveyor.
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 He was a surveyor. Surveyor, he cannot say how many clients are there. One client may give 2 lakh, one client may give you 20,000. Depends upon the work of the survey.
No document support of surveyorship has been filed.
But the income tax.
Income tax
return is filed.
that is in record.
And that is also proved as marked exhibit.
Another,
15.
what is the another ground?
Lordship, another ground is default interest is given, not.
Where is that?
That is in the order. Then I'm
OP
sure.
number 2, Reliance General Company is directed to pay the award amount to the above mentioned petitioner within 2 months from the passing of the
Lordship,
order.
page number 38.
Yes, I got it. Liable to
6%.
pay rupees 6% per annum from the date of filing of the
From the date of
case. Is
filing.
it-
And
So
this
automatically it has been gone. 2 months has been over.
Lordship, enhancement of interest also, that is our ground, another ground.
Yes, what is your appeal? What is the ground in appeal?
Lordship, actually, the deceased was traveling in a car, and the insured vehicle was standing in front of, and they dashed behind. They coming from the behind, dashed the stationary car. So, and both the drivers were
No.
just-seated.
The deceased was
tra-
driving the car.
No, he was
He
not.
was sitting in the car.
as per
Sitting
the-
in, he was sitting in the
sitting in the,
passenger.
beside the car. He and from behind, the car dashed the front side car, which was stationary car vehicle.
From behind the car, that's the
Front side vehicle.
vehicle.
And both the drivers were charge sheeted. And it has been stated in also the FIR. So my submission is both the vehicles are liable. So at least, so.
Where is the cross-examination?
And it
May I show,
is
Lordship, may I
admitted
show?
fact.
May I show?
Yes, where is the
Lordship,
cross-examination?
Kindly see the page number 24. Cross-examination on behalf of the petitioner. Above mentioned policy was issued in respect of the vehicle number such and such. The time of the accident, the policy was valid. It was not mentioned in my affidavit in chief that the offending vehicle was parked in no parking zone.
This is the affidavit in chief. It's a cross-examination.
Yes.
It was not mentioned in my affidavit in chief that offending vehicle was parked in no parking zone. Not a
That is why the accident took place. It is admission.
And where is the cross-examination of complainant? Claimant?
Lordship, I am sure.
Where is the cross-examination of claimant? Claimant was examined.
Lordship. No.
Claimant was not examined.
Examine.
Examine.
Where is the examination of PW1? Momita Mitra,
Momita Mitra, Lordship.
Page 12.
page 12, 16, 12, 16.
Case 12 is
16 is
evidence
the
in chief.
cross-examination.
16 is the
Cross-examination.
cross-examination.
I did not the witness to the incident. I can PS and at the time the victim was at the random time victim vehicle was driven by the driver. I heard that the driver was driving the vehicle. Then was the owner of the victim vehicle. I cannot remember the registration number. We got the 5 lakh from the insurance company.
50 lakhs, Lordship. That has been tried wrongly.
Huh?
My claim was for 50 lakhs.
No,
That
no.
No. He got 5
Cross-examination.
lakhs from the.
We got the claim of 5 lakhs from the insurance company due to the death of. Where from you got it 5 lakhs?
Actually, he was the owner of the car
We got
on
that.
which he was traveling. That was insured cover. And accordingly, from personal pay claim, he got 5 lakhs.
Acha, that another one.
That's
5
another.
lakhs. 5 lakhs.
Lordship, more so, insurance company choose not to adduce any evidence,
Yes, the evidence chosen from.
but not in that point.
Just a minute.
This
Just
part.
eyewitness PW2. Bholanath
Yes, Lordship.
Karmakar.
Lordship, yes. Not a fact, I did not witness the accident.
You kindly come to the page 20. You're not made out your case during cross-examination of
Lordship.
the eyewitness. During eyewitness, you're not made out a case that the truck was standing and your car came, the car came from the behind and dashed the standing. Where is that? What you are stating? Kindly come to the page 20 and cross-examination of the eyewitness. You're not taken that stand.
Nothing is. PW3 is from IT department. Next page.
It is the PW2 stated in his examination chief also, this fact.
PW?
That is the eyewitness. Para 2.
I say that on that day, accident 19th afternoon at about 2, I saw the motor vehicle accident which was occurred at Calcutta, Pakka Road near the Samaritan I saw the Anwara Mitra was going toward the Pandapuri side of Calcutta by traveling the car in a normal speed along with the left side of Farakka Road along with his relative and his driver. At 2:20 when they reached near the Samaritan petrol pump, at the temper bearing registration which was standing on the no parking zone.
Yes.
No parking.
No, whatever maybe, he was coming from behind. The driver should have seen that the car was standing.
No parking zone.
In no parking zone, why car?
He was
Without giving
standing
any signal
and the driver was
opposite Mahindra
coming
dashed-
from behind for long distance.
dashed back some dumper with the
So irresponsible of the driver is there.
with the heavy impact. As a result, with the now sustained injury on his personal died on his spot. The other person is but he was not the driver. The deceased was not
This
the
is
driver.
the owner. He was
Yes,
sitting
he
behind.
was owner and he was not the driver.
He had no control.
Just he was not a driver, and the police has charge sheeted both the accused persons
Both the accused persons.
of this driver also, of that driver
Driver
also,
also.
because no parking and he stand. So how this you can debar these persons who was traveling in the vehicle?
No, lots
If
of-
he was driving the vehicle, the owner himself is driving the vehicle and he dashed the vehicle from the behind, charge sheet is against him, then okay, he cannot. But he was the passenger. Might be the registered owner of the vehicle, but he was the passenger. And the driver, or the negligence of the driver, how you can say?
Actually, it was the not sole negligence on part of the driver of the front side vehicle. It was the negligence on part of the, this is a composite negligence. So that award should be apportionate, and at least 30% should be deducted my submission.
Lordship, where is that evidence?
Who are the insurance company? Both insurance company against whom you have filed the case?
Reliance Genesis Company, who was the front side vehicle, standing vehicle, stationary vehicle.
Of the truck.
Attending vehicle, that truck.
Truck, stationary vehicle.
But you have not made your car, your driver, your car,
No, they did
your
not make-
insurance company as a party.
No.
Then
Lordship, my insurance company, no is liable. I think
why?
there is no contributory release and they never.
Charge sheet is against you also, your driver also.
Lordship, claimants are the heirs of the deceased.
No, it is your case. The examination in chief of the PW, who has filed the examination chief of the PW2?
He, claimant side.
It is your case. And where charge sheet has been issued against both the persons. FIR are against both the drivers, of the car driver and the truck driver.
Both vehicles are seized.
So your vehicle is insured. And you got the 5 lakh rupees, then you have the 5 lakh rupees is to be either it is to be deducted. 5 lakh rupees is to be
It is to be
deducted. 5 lakh under what provision? The 5 lakh you have, where is the evidence? 5 lakh rupees for what? It is only for the repair of the car or the liability? What is why?
Actually, the owner's car was insured with the company.
That's correct.
And accordingly they have paid, but no documents have been submitted in support of that.
5 lakhs has been paid with regard to the repair of the
No,
claim.
personal accident claim. PA
Personal
claim.
accident claim.
Yes, personal
So-
claim. PA claim. Covered with driver, owner was covered with the insurance. PA accident claim.
Only 5 lakh.
Only 5 lakhs coverage. They have stated as per their statement, but they did not produce any insurance certificate.
And whether both the charge sheet you have disclosed the both charge sheet.
Yeah,
You have disclosed both the charge sheet, both charge sheet.
to see.
Where is a written statement to the claim petition?
Lordship, answer. Lordship, page number 7 onwards.
Page number 7, I have stated that. Para number 7.
Non-gender parties.
Yes.
Counter vehicle bearing registration number. So your vehicle number is 63363.
No, my vehicle number WB74AE. No, my vehicle number is.
You are appearing for whom?
I am for the truck.
You are the owner, not the insurance company.
I am insurance company.
WB71A
8783.
8783.
And
The offending vehicle.
this is traveling with the vehicle WB74AE 6663.
Huh?
This is traveling with the vehicle WB74AE.
Mahindra Conto.
Yes.
Mahindra Conto is of the deceased.
Deceased.
And where is the vehicle? The truck.
Lordship, at paragraph number 14, written statement.
8783.
Yes.
So you are who is the insurance company? Which insurance company? Your insurance company or the
No,
truck
no,
insurance
No, no.
company?
I am the claimants.
Huh?
I am the
No. You made where is the complaint? The
WB71A 8783.
no insurance company. Who is
This company was for this vehicle.
car?
Truck, which was standing in front of site. only owner of this vehicle and insurer has been made party.
Reliance Insurance.
So,
Insurer of this vehicle, which was standing in front of side. Front side vehicle.
In front of side means?
Front of, it was standing in front of
It was
the,
standing in the no parking zone.
standing
It
in
has
front
to- it
side
has
and the dash from behind.
you not made a party.
Lordship, may I take instruction? May I come tomorrow?
What?
In which company it was insured?
No, that's why I am thinking I will set aside and remand back, giving a liberty to make the insurance company of your car also and to frame the issue, which insurance companies are, because both have been charge sheeted and this is the 166, not 163. 166, negligence and contributory both are there. You have been a hard case to prove. And the tribunal has not taken into consideration.
But
is a-
Lordship, they have not produced any evidence.
May I
regarding
be,
con-
but the
contributed
WO,
negligence.
kindly see the WO. Kindly see the WO,
Did-
paragraph 7 and paragraph
They
14.
took the plea but not adduced any evidence. That is the,
That is different thing, but the court has to see if they have not adduced the evidence that if the case is going ex parte, the court can be, without going to the merit, the decree can be passed.
It is the duty of the claimant to make the party.
And he has taken the plea, non-genre party.
before tribunal, no evidence regarding contributing negligence is.
But your PW2, you admitted.
Yes, sir. Company has adduced evidence. Page
PW2,
22.
you admitted. Kindly come the PW2.
Lots of company adduced evidence. Page 22.
Page?
22.
That I have already read. Page 22 starts, Lordship kindly sees page 24, Lordship. Cross examination, page 24.
Page?
24, cross examination.
Yes.
That is what I'm saying.
Presently attached to the instances and so the affidavit chief adopted lawyer. Deny you.
This is clear admission
What?
that he admitted that I have not stated that the vehicle was offending vehicle was parking in the no parking.
But your PW2 admitted, your examination chief, kindly come to the examination chief of PW2.
It was standing.
Kindly come to the page 18.
Lordship, and
Then you are admitted. And the page 24, you can come.
which was standing on the no parking zone of Calcutta.
You are admitted. And kindly come to the page 23, page 22, page 22, last paragraph. I say that as per the summon of claim received the connection with the aforesaid case, only the owner of insurance company standing vehicle number has been added as a party and the owner of the insurance company of the offending vehicle has not been added as a party. As such, the claim of the defective and non-genre necessary parties. There's no cross-examination on this. Where is the cross-examination on this? It is a specific case of the insurance company.
One line was there, not a fact that the accident took place due to the negligence of vehicle being number such and such.
That is
That is
different,
often-
sir. See, ascertain the facts. Both the vehicle might be in a non-parking zone, but your car dashed from behind. Correct? And the unfortunate, the owner died. Police has registered the case against your driver also, against the vehicle, the truck owner also, or against the truck driver also. So now you have made the truck driver, truck insurance as a party here. Insurance of the truck. But the police has initiated a FIR and charge sheet has been filed in both the cases. So contributory negligence. And they have already taken the plea in this. And it is also admitted in the examination chief. And this is the case of 166, not 163A. If it is a 163A, okay, contributory negligence we can avoid. There is no necessity of evidence of the negligence. (163) only if the accident is admitted, you are entitled to get the motor. But 166, negligence is to be.
Lordship, kindly see the 34 paragraph, last paragraph from the last paragraph.
Yes.
It is discussed. Page 34, last one. Though charge sheet was filed against both the vehicles.
That is, I have been aggrieved.
And they produce nothing.
Now come to the page 27.
27.
Yes. 27, issue number 3. Was the vehicle bearing surfaces involved? Correct. Then was the accident caused on negative driver of the part of the vehicle? 83 in lever side. Then was the vehicle bearing coverage incident? That no. Now come 6. Is the case bad for non-jointer of the necessary parties? These are the 2. Now come to the issue number 3, where the issue number 3 is decided. Kindly come to 31. 3, 4, 5, 6, 7, 8 has taken together. Where is the issue number 3 decided?
On the part of the offending vehicle is equal to proof for the compensation claim in accident involving accident of motor vehicle where death of a permanent disabled results. While on the other hand, the defense has the usual defense of contributory negligence. Nowadays, certain positions of law.
Where from your reading? Page?
32.
Yes.
On the top. Nowadays, settled position of law to arrive at just cause of the survivors of the disease by following the scale of multiple specific Sarala Bharma, such and such, with further prospect of other benefit excellent consideration, that is Ponacity. And here is the case before revision.
Where is that? Issue number 3 and issue number 6?
Specifically not stated. Specifically not stated.
Where is the decision? No decision. There is no decision on issues.
Though it is considered by the landlord for the insurance company that the vehicle of the disease was also responsible and involved with the accident, but the insurance of the said vehicle has not been made party in the instance case, and OP2 is liable only to pay half of the award.
Then where is the issue?
Though
Where is the
charges was
decision?
filed- though in the charge sheet is mentioned that during the is a fall of the accident. The part of the driver being driven by accused driver. Accordingly, charges was submitted against him as well as driver. These are the department support of the introduction deduction on the ground of children.
Nothing. Okay, CAV.
In course of evidence during this was
So I am setting aside, remanding the matter to the tribunal to decide the issue afresh.
As your lordship.
No, you see, if you are satisfied, so satisfy me. Where is the decision of 3 and 6? Issue number 3 and 6.
I read enter, but that is lacking, and that is no fault on behalf of both the parties. So I can't say upon that anything. Lordship, pass the necessary order, whatever
The
serve the purpose of both the parties.
claimants as well as the insurance company, both being aggrieved and dissatisfied with the award passed by the London Tribunal, London Motor Accident Claim Tribunal. Motor Accident Claims Tribunal. Where is that? Claims Tribunal. In MSCC case number Motor Accident Claims Tribunal, and क्या बोला? In MSC case number 323 of 2019, dated what is the date? 3rd October. Dated 3rd October 2024. Have filed the present appeals. Full story. Learned counsel for the claimants have filed the appeal on the ground that the deceased was the surveyor and used to file the income tax return return. And lastly, he has filed the return for the assessment year 2015-16, wherein the total income was 2,97,070, and the deceased paid the income tax of rupees 3,000 on 19th April 2016. But the learned tribunal, while considering the income of the petitioner while awarding the compensation, has taken into consideration of the annual income of the deceased as average annual income of the deceased as rupees 2,45,000 instead of 2,97,070.
Less tax.
By by deducting the tax of rupees 3,000. By deducting the tax of rupees 3,000. It is the further contention of the learned advocate appearing for the claimant that the tribunal has awarded lesser interest at the rate of 6% per annum instead of 12%. What you claim? 9% per annum. He further submit that the interest awarded by the learned tribunal is also a conditional one. As per conditional one, we submit that in the award it is mentioned that if the insurance company failed to pay the awarded amount of rupees 39,28,750 within 2 months from the date of passing the award, then only the insurance company is liable to pay the interest at the rate of 6% per annum from the date of filing the case. The insurance company has filed an appeal challenging the award on the ground that it is the case on the ground that it is the case of the claimant that the truck involved in the instant case in the accident was parked in non-parking zone, and the car of the victim dashed against the standing truck from behind, due to which in which the deceased was traveling, and due to the said accident and the deceased died in the said accident. But the police has initiated case against both the driver of both the vehicles, and as such there are the facts of contributory negligence on the part of both the drivers, but the learned tribunal has taken into consideration of the negligence on the part of the truck and driver of the truck without considering with regard to the contributory negligence of the driver of the car in which the deceased was traveling. Full stop. Learned counsel for the petitioner, the insurance company, further submits that the claimants had the knowledge that the police has initiated the FIR against both the drivers of both the vehicles, but the claimants have not made the insurance company of the car in which the deceased was traveling. Full stop. Learned counsel for the insurance company further submits that the learned tribunal has also failed to consider that if the police has failed to consider that the claimants have filed the claim petition under section 166 of the Motor Vehicle Act, Thus, the claimants have to prove the negligence against the truck. But the fact remains that the police has initiated the case against both the drivers, and without considering the same, the learned tribunal has come to the conclusion that there is a negligence on the part of the truck driver. Full stop. Learned full stop. The counsel for the insurance company further submit that the tribunal has rightly considered the annual income of the claim of the deceased of rupees 2,45,000 as the claimants failed to produce any documents with regard to their stability of the income, stability of the annual income. Thus, the tribunal has rightly considered the average income, taken into average income for the year 2013-14, 14-15 and 15-16. So, had the learned counsel for the respective parties peruse the award passed by the learned tribunal, which is impugned in both the appeals, and the documents and the evidence led by the parties during the trial. The claimants have filed the claim application claiming compensation on the ground that the deceased was traveling in the car, but the truck was parked in the non-parking area, due to which the incident was occurred, and due to the said accident, the deceased died.
And it is the choice of the claimants that against whom they will prefer claim.
Insurance land counsel for the insurance submits that. उससे पहले जहाँ plaintiff का हुआ में learned counsel for the claimants further submit that it is the choice of the parties to add or delete and to implead any of the parties for claiming compensation. He submit that in the present case, the claimants have chosen that due to the negligence on the part of the truck driver, the accident was occurred, and as such, the claimants have made the insurance company of the truck, insurance company in which the truck was insured.
Grateful, Lordship.
Truck was insured.
Grateful.
And the last में क्या बोला? Last time क्या? Incident and due to the said accident, the deceased died. This is succumbing. ठीक है, this is full stop. Full stop. The petitioner, the claimants have filed the claim application under section 166 of the Motor Vehicle Act. Motor Vehicle Act. If the petitioner choose to as the petitioner has filed the application and the claimants have filed an application for claiming compensation under section 166 of the MV Act. Thus, the claimants are claimants have to prove with regard to the negligence driving on the part of the truck driver. In the present case, in the case in hand, it is not the case that only the FIR or investigation has been carried out by the police against the truck driver. It is admitted case that the police, after the said incident, the police has initiated the FIR against both the truck driver, and on completion of the investigation against both the driver, both the drivers of the vehicle, both the drivers of the respective vehicles. On completion of the investigation, the police has submitted charge sheet against both the drivers, and the said case is pending for adjudication. The insurance company in the written statement, have in the written statement in paragraph 7 have categorically stated that the police authorities have also filed criminal case against the owner and driver of the car. It is also admitted that the deceased was the owner of the car bearing registration number WB 74-AE-6663. In paragraph 14 of the written statement, the truck owner of the insurance company has denied that the accident was occurred due to non-parking of the vehicle of the truck and due to parking of the vehicle in the non-parking area.
Without giving a signal.
Huh? Without giving a signal. Without giving a signal. Full stop. After considering the pleadings of the parties, the learned tribunal has framed the issues
Yes, 31.
page
27.
Frame altogether
27.
8 issues which are as follows. Page 28 8 issues. Full stop. The learned tribunal has taken up the issues number 3 to 8 together for decision. Issue number 3 is whether the vehicle bearing number WB 71 capital A dash 8783 within bracket dumper was involved in this accident. And issue number 6 is the case bad for non-joinder of necessary party. Though the learned tribunal has taken up all issues number 3 to 8 together for decision, but has not taken any decision with regard to the said issues, whether the vehicle bearing registration number WB 71 capital A dash 8783 within bracket dumper was involved in the accident, or whether the claim petition filed by the claimants are bad for non-joinder of necessary parties. The learned tribunal in page 10 of the award has taken into consideration that though charge sheet was filed against both the vehicles, but it is the choice of the petitioner against whom he will proceed to claim compensation due to demise of the victim. Full stop. In the case in hand, it has been established that the vehicle bearing number WP 71 capital A dash 8783 was standing on the national highway at a place which was not a parking zone, and due to such negligent act of the driver of the said vehicle, the accident took place. Full stop. In the charge sheet, it has been mentioned that due to negligence act of the driver of the dumper, the accident took place. The documents filed by the claimants leads this tribunal to hold the victim Anurava Mitra since this is expired on the fallout of the road accident that occurred on 19th October 2016 due to rush and negligent act on the part of the driver of the vehicle bearing registration number WB 73 capital A 8783 being driven by the accused driver Silvanus Urao, and accordingly charge sheet was submitted against him as well as the driver of the victim of the vehicle. Full stop. So, not come across. Though the London Tribunal has taken into consideration of the charge sheet filed against the driver of the vehicle, the London Tribunal had also the knowledge that charge sheet was also submitted against the driver of the victim vehicle. But the London Tribunal failed to consider with regard to the charge sheet of the victim vehicle victim vehicle. Full stop. Though the charge sheet is not on record, but unless until the police has not come to the conclusion that the driver of the victim vehicle is also negligent in the said accident, for that only the police has submitted the charge sheet and the said aspect has not been considered by the tribunal. And has come to the conclusion that the driver of the truck is involved in the loss and negligence driving of the said incident. Full stop. Considering the full stop, the tribunal has also not taken into consideration whether the insurance company London Tribunal has also not taken into consideration. The London Tribunal had the knowledge that the police has initiated the case against both the drivers of the vehicles and has filed the charge sheet. Thus, whether the insurance company of the car in which the victim was traveling, the deceased was traveling, with the necessary party or not, has not been decided, though the issue was framed being issue number 6. Full stop. Considering the above, this court find that the tribunal has to consider the claim and the counterclaim of both the parties afresh by giving an opportunity of hearing to both the parties to lead their Accordingly, the impugned award passed by the London Tribunal dated 3rd October 2024 is set aside and quashed. The MACC case number 323 of 2019 is remanded back to the London Tribunal, that is Motor Accident Claims Tribunal, London ADJ First Court at Jalpaiguri, to decide the issue whether the insurance, whether there is any contributory negligence on the part of the driver of the vehicle in which the victim was traveling. Whether number 1 karo. Number 2, whether the insurance company of the victims of the vehicle in which the victim was traveling is the necessary party. and this is a necessary party, and whether there is any contributory negligence on the part of both the drivers.
That is whether the insurance company adduced any evidence relating to the contributory negligence by adducing any.
No, that's I am remanded, now set aside.
That is the decision of the tribunal.
Then you can take either, you can also adduce evidence, you can file an application, that full stop. क्या बोला? वो कर दिया, 3 दे दिया ना, full stop. The both the parties are at liberty to take appropriate steps for amendment or deletion or addition of the parties, and also to adduce the evidence, full stop, after complete full stop evidence. The learned tribunal is directed to dispose of the said MSCC case number 323 of so as expeditiously as possible without granting any unnecessary arrangement.
Actually,
No, period the
accident took place 60. This is 2026. Nothing.
as early as possible, preferably within a period of 6 months from date. From date. The specific due to as the accident was occurred in the 2016, considering the age of the case, this court has directed the learned tribunal to dispose of the case within a period of 6 months from the date of receipt of this order.
Grateful.
The lower court record আছে কি ওখানে? The department is directed to immediately send back the lower court send back the trial court record. ठीक है?
Item number 24.
I'm appearing on behalf of the
Item number 24, my lord, I am appearing for the appellate insurance company, my lord.
Board dispose of, board dispose. Yes.
My lord, I have already obtained stay and deposited the entire awarded amount, my lord. The direction for paper book may be given. My lord, I have given the cost for service of notice to the appellant, respondent claimants, my lord.
No, we did not receive, we only received the notice, my lord. Did not receive any memo of appeal or my lord anything. Let there be direction and my lord also a direction to file a paper.
My lord,
so,
my lord, kindly see the order dated 7/11/2025, my lord. I have filed the affidavit of service, and thereafter I have also given costs to be put in for speed post with acknowledgement due to the department for notice of appeal to the respondent. In spite of that, if they have not received, I will give.
When you deposited the awarded amount?
My lord, I have deposited the entire awarded amount on, my lord, 26/11/2025, challan number 67, my lord.
26?
26/11/2025.
Notice arrival of trial court report so that one, when
Challan number 67, my lord.
67?
My lord.
Learned counsel for the appellant submit that the appellant has deposited how much amount have deposited the awarded amount?
My lord, in
Of
total,
rupees?
I have deposited 65,80,347, including the statutory deposit.
Including this statutory deposit amount of rupees 25,000?
65.
By before the 65 lakhs and the 25 is the statutory.
65,80,347 I have deposited in total, my lord.
In total, it is including the statutory amount.
My
Counsel for the appellant submit that the appellant has deposited 65 lakhs in amount, including the statutory amount. Full stop on 26/11/2025 by challan number
67.
by challan number 67. Full stop. The department is directed to verify the same and to submit the report on the next date fix. The appeal is admitted.
My lord, another thing is, my lord, kindly give me liberty to final application, because my lord, as according to in item number 13, I submitted that Reliance General Insurance Company has been taken over by Indus General Insurance Company. My lord, an application has to be filed. My lord, kindly give me at least 15 days time.
What?
Well, let it be in the next week, my lord.
The appellant is directed, the counsel for the appellant submit that the Reliance General Insurance Company Limited has been taken over by
Indus General Insurance Company.
Indus General Insurance Company. Accordingly, she prays for time to Indus General Insurance Company. Accordingly, she prays for time to take appropriate steps for correction in the cost title of the appeal. In view of the full stop, the petition granted leave to take appropriate steps for amendment of the name of the appellant in the cost title within a period of 2 weeks from date. Full stop. The appellant is directed to file requisite number of paper books within a period of 3 weeks after serving the copy to the learned counsel for the petitioner, counsel for the opposite party. List the matter before the next available circuit bench.
Check.
Informal paper
Next.
book, my lord.
Yes, within 3 weeks.
Grateful.
My lord, informal paper books I will serve upon the claimant respondent.
Correct. Yes.
Good.
Next.
I am grateful, man.
Order.
25. Why?
Lordship, I appear for the NCB. Am I audible, my lord?
Yes. Have you gone through the order? 11th May order. So why you are making the submission? You are not gone through the record. Yesterday the matter was prayers. You are not appeared. Today not today. What is the matter? So I am dismissing. Yes, Mr. Majumdar.
Lord, he's a junior counsel. What should I say, my lord?
What can be done? I am fed up with the
Lord, I
advocates of the
understand.
circuit bench of Jalpaiguri.
My lord, I understand.
None of the advocates want to do the matter.
My lord, but my lord's frustration is very justified. But my lord, we feel constrained when we are faced by junior counsels.
Why the junior? Why the senior is not appearing in the application? Is filed?
Very, very unfortunate, my lord. Very unfortunate.
So then the music is to face by the juniors only. If you have taken the risk of the seniors.
My lord, in the end, it is the litigant who suffers, not the counsel. My lord knows very well.
What can be done?
I leave it on your.
So
lord.
I don't know how the advocates are answering to the clients. For the last 3 days, the same thing is happening.
My lord.
For the benefit of the litigants, the court has opened. You are filing an application. When the application has come before the court, without any preparation, you're coming before the court. Not today. Next, 26. Yes. What is the application for? Anticipatory bail. Who is for the state? Nobody. So, which the is there any chance to appointment of the advocate, state advocate? Next Monday. As none appears on behalf of the state, एक का काम करो, ट्यूसडे रखो. Next. Call. Why you taking time?
27. 20.
None appears on behalf of the petitioner. No accommodation is sought for. CRM number so and so is dismissed. CRM A 277 of 2026 is dismissed.
28.
For the petitioner is what?
Yes.
The anticipatory bail application, your lordship, under section 108, 61 subsection 2, and 6 subsection 5, your lordship. Our prosecution case is that
Have you served? To whom? When you served the PP office? When you served the PP office? When you served the PP office?
1 week before, your lordship.
Before the result?
Yes, your lordship.
Before the result. Then after the result, whether PP is available? Then
And these are the statement.
the none appears on behalf of the state. Full stop. The petitioner has filed the present application for grant of anticipatory bail in connection with Birpara PS case number 195/2025 dated 13th of November 2025. Full stop. The inspector in charge or officer in charge? The officer in charge of the Birpara police station is directed to produce the case diary in connection with Birpara PS case number 195/2025 dated 13/11/2025 on 19th May 2026. The petitioner is directed to communicate this order to the officer in charge, Birpara police station, for compliance. Next.
Item number 28 also.
28 is the whole.
28.
29.
Same PS, same case.
Yes.
Two petitions have been filed.
Yes.
Same order. Next. 30. Today itself you communicate this. Yes.
It's an application to
Say nobody is there. In any case, both the parties are there. In any matter, both the parties are there.
Item number 33.
Both the parties are there.
There is also an application for anticipatory bail. You will also kindly take the matter and call for the case diary.
Yes, any both the parties are there.
I would like to.
Who is the other side?
Other side is what
State.
white. Other side is white.
Yes, give 38. Criminal revision, criminal motion. See now what the court will do. No, I will hear you. I am telling, if you persons will not do them, what the court will do?
470.
Neither in the private cases you are coming, nor in the state case you are coming. What? You could have been taken the resolution prior to that, not to send the circuit bench. Ten days time is sought for affidavit in opposition.
They have not given me.
9th April.
Now, in the meantime, what has happened? What has happened?
Who are you?
The husband.
You are the husband. What is the application?
It's about interim maintenance.
Interim maintenance. You are the husband. And the opposite party is the wife. Only wife or child also there? Only wife. Where is the impugn order? Where is the order which is impugn in the matter?
The court had already recorded my application.
My lord,
My prayer was that.
my lord, I am for the opposite party. My lord, Mr. Milindu Pal is engaged in this matter. He's
Huh?
on, Mr. Milindu Pal is engaged in this matter. He's on legs before court number 7, my lord.
Okay, let it come. I will hear him. Yes.
And you already did 50% is also
31st? 31st? Passed by this court?
There is a record. It's an application where they see that not dated 8/10/25 by which the court window granted immediate maintenance to the opposite party by $35 for health or myself for the date of filing the maintenance on filing the maintenance in disposal of the case. It is submitted on behalf of the petitioner that the petitioner at the initial stage did not take any maintenance or when the petition is almost on the order of obligation, she has come out with the instant application on 13th November 2024 to the period for banking maintenance of 1 lakh per month, which is similar to original prayer for maintenance. Further submits that the wife of the party in her evidence has admitted that in the terms of the order passed in the order, he has provided the basic necessities to his wife of the party as a granting of maintenance, which was double divided. Further not announced, after that, the direction to give the copy on the of the party. We have served and also why I am coming to the after page 54 is the instrument.
More than 4 lakh is due, my lord, towards maintenance.
Yes. Where is the interim order? Page 44. Yes. Fix or passing order in respect of interim maintenance. The petition mentioned that the interim maintenance. Yes, read.
This is for passing order in respect of interim maintenance by the petitioner or both sides on the last occasion. It's important to mention here that maintenance and that we filed by the petitioner at state level which we paid off the ordinal application under section 125 CL. The petitioner is in short is that she paid for implementation, 1 lakh per month from OP or husband from the date of filing of such case, along with other duties on the ground of the declaration of her mental health day by day due to the severe financial crisis, especially including the expenses for the education, training, since 4 years. The basic daily expenses and medical expenses which was spent by the father who is 75 years old. She came to be the renowned businessman having business of banking exposed with the name of name and stand not from the last across the globe and speaking one of the director of the said business having monthly income of 25 to 30 lakhs per month. Apart from that, he is also running the business of bakery and confectionery. The name and stand of Vijaypali Bakeries and he alleged that since the time of filing of this case, he had not been provided maintenance after her, and she is without money suffering from severe financial crisis and undergoing mental health. And since she was tortured, heavily degraded, and alienated by the king and his family, so being compared to requires maintenance and on the other hand, he by filing an objection denied all the mental allegations leveled against him and family members and stated that the petitioner has filed this application at created stage with a verified intention to cause harassment to them and the wrongs taken by her for provision expenses for extra technical leisure and merriments. She had fought for an exorbitant amount as her maintenance to the tune of 2,20,000 per month. The risk is about 10 of 2021 under the Act, taking into the very future mentioned value. Further stated that she is well educated and to work as a care process as well as taken course of bakery. He had practices against OP and his family members of the ticket and has been and by the means of the learned procession Jalpaiguri while granting the OP had
He directed to provide all the facilities needed for the maintenance as per our demand and inform to set order and to offer effort. Supply all the essentials and other requirements as per our order at 6 and the price of food, ensure the goods and articles supplied to her as per demand, such as 28 certificates available or 28 certificates available to 76 kgs of almond milk, etc. Exorbitant claim. Her father providing all expenses. That the father of the Uki at such old age has been working for the welfare of the family. Further, made allegation that she and civil harassment can give very bad unless demands money and partition of family she going to part of law. Stated that he had to leave the house and had to take special investments that by also and cases filed by her as he was not in position to show his face well. He has no personal source of income and all demands of his state of his family because of further harassment and sadness their question. However, he mentioned in paragraph 20 of the document that he never refused to maintain her and she still maintained in the opposite matter. Answered the regular financial department of the materials temperature of record. This is the factor of the legal marriage of the party on 8/7/28. While petitioner has already of naked and the party of yes, but that has caused mental harassment and state on the ground of the country. Business and having a relationship which to such a situation that not in any statement that he wants to see his family life, which he belongs to a renowned family in Calcutta and speaks and he has attempted to look after equality. We cannot responsibility to maintain his wife according to his status. He was responsibility for both the parties in this evidence on because he was for the court to educate on the arrival financial and state of the and this is not has come out because the
Yes, so what is the wrong? So what is the ground for challenging this?
The evidence, evidence herself she has induced that.
How the evidence? Where the evidence here? Is the interim application?
In the 120 application, they were evidence which has been.
So what is this application? This is also 125.
Yes, yes. During the course of 125 application, they are by interim maintenance.
Correct.
Interim maintenance is allowed.
What was the stage of the when the interim application was not at the stage of initial stage? At the time of trial.
She has report consultation was done, and after that she has filed this.
Where is the evidence? When her evidence was recorded? When her evidence was recorded under in the application under 125.
Page 25, madam.
Huh?
Page 25.
Like
27, madam. 27.
Page 27.
Page 29 is the relevant portion. Other examination chief of the one position related to Brahma Devi have on
29. Yes.
I spend around 8,000 to 10,000 suffering from depression. I am domestic. I am domestic and darling, I am to some of rupees
6,000. Yes.
advised by my doctor to perform yoga, and I have to pay him fees 8,000. And further for 15,000 a month of yoga. I have also put water every month for me. I have to pay 3,000 and dogs take care. And for the nice letter of 1 piece some of 2,000. And also how much time to come to pay some fuel? Actually, that was recorded on my I am presently provided to keep the grocery, vegetables, and electricity bills. But the parents also nothing more provided to me. They only provided me with vegetables and grocery, which they think if I ask for anything expensive, they not Within the understanding at facts, the brother of me and for the same, I will not see any data. I also get the link which is available on output data bank and the same on Victor also. I am not getting my necessities from the other side, not according to the direction of the government. Now, I have done my best on the English OP service order as such completed this last year. What I'm basing on in this definition is that the void of service order is indirectly based upon this parent culture. The parent is giving the source of income to the income, and that source of income budget in which funded by application was budget CS5 budget. The parent is giving the white government. SLT actually is being provided in clause the SCAs. And I don't have any information so that after owns property that have been
I do not have any document to show that Nathula's own Nathmul's, yes, own properties at Darjeeling, Siliguri.
Page 31 also. Next page.
Yes.
Item 6. It is a fact that the point 19 failed to silence and 9 of the proceedings under section 498 of the scheme. So this IBC initiated by me, the court had several conditions asking the LPs to provide me certain disabilities. Thereafter, my in-laws have been providing me groceries, vegetables, electricity, any kind of that. But I am water because the other side is deliberately closing the faucet bill by the supply and thereby causing covered duty, for which I have to purchase water at time. But the other side, they have provided me with clothes, toiletries, and other basic needs for women. And we are able to start my own business if I get the chance. That is also before the year. Right now, I'm deciding on kind of flat and I was meeting with my 2 dogs and I do not have any gate service. This whole building belongs to the own because. So, my submission is that she's been getting logic basic needs and amenities by the in-laws and regarding the maintenance work, I would like to say that can be set aside or not shift can be modified now.
Yes.
They have 3 outlets. First, my lord, I would like to raise a technical objection. While hearing this matter, a coordinate bench of this honorable court raised the preliminary issue with regard to maintainability of this application, my lord.
Where is
my lord,
that?
if you also kindly sees, a coordinate bench has passed this order, my lord.
In this matter?
No, in a separate matter, but the coordinate bench has raised the issue that I have passed an order in another matter, where when there is when there is if you also kindly comes to page 8 of that order, paragraph 6, my lord, the distinction has to be made between the issue as to the maintainability and entertainability as far as the maintainability is concerned. There cannot be any doubt that the revision petition is maintainable before the High Court. However, the issue is that if there are concurrent jurisdiction with Session Court and High Court, the aggrieved person should first approach the Court of Primary Jurisdiction or should ordinarily invoke the jurisdiction of High Court at the first instance. Even at the cost of repetition, it may be stated there that there could also be cases of grave, serious, or urgent in nature where the intervention of High Court may be necessary at the outset. However, there is no such plea of gravity, seriousness reflected in the present case. This court is of the firm view that even if the concurrent jurisdiction is available, it is a matter of propriety and judicial discipline that the petitioner must approach the first forum and invoke the jurisdiction of the High Court only in rare and special circumstances. This will not only benefit the litigant by having another remedy available as per law, but it will also help in declogging the High Courts. The High Court has always plenary powers, even other than revisional jurisdiction, to correct the wrong. This aspect has also to be seen from another perspective, particularly in a big state like West Bengal. It will be very difficult from the far-flung areas to approach to the High Court, and relatively it would be convenient both physically and economically to first invoke the jurisdiction of the learned session court to address their grievances against the order passed by the learned judicial magistrate. In view of the discussion made herein above, this court is of the considered view that though there exists concurrent jurisdiction, however, as a matter of propriety and judicial discipline, ordinarily the order of learned judicial magistrate should first be challenged by way of revision before the learned sessions court, instead of directly invoking the jurisdiction of this court, except in the exceptional and grave circumstances. However, this shall not curtail the power of High Court to entertain revision petition in exceptional cases. It is pertinent to mention that no such grave or exceptional circumstances exist in the present case, nor the same has been pleaded or canvassed before this court. In view of the above discussions, the petitioner may file a fresh revision petition before the learned sessions judge. In the event of the revision petition is filed within 4 weeks of this date of this order, the period taken during the revision petition will not come in the way for the purpose of limitation. It is also to be made clear that all the contentions shall remain open and shall be agitated and decided by the learned session judge expeditiously in accordance with law without being influenced by this order of this honorable court.
Yes.
And hence this application is not pendable because
we are coming on the
yes, first, yes.
I know. Like something that ODC had enough powers of enough powers what happened that why regarding the urgency motion. Now against every something against traditional WA has been issued. Now I want to say I want to project from surrender before the but until I pay certain amount, the court is not allowing my WA to be set aside. That is the reason why once I come before blockchain. And also since the 125 proceedings was at the fact in blockchain, he interim maintenance and
When the warrant was issued, when the order was passed, July 2025, when this revisional application was
Prior
filed,
to that.
when this revisional application was filed,
15th day of September.
15 September. And what is the impugned order dated? July. Okay. Then what has happened after July? What has happened?
the court below lordship is hearing the matter, lordship, and lordship the court has asked him to pay a certain amount of money to the then lordship the warrant of arrest.
But Mr. The 31st of October, you are not challenged the order. 31st October, the revision application is admitted. Now at this stage, you can take the.
Well, at that time I was not there now.
Whatever it may be, it is admitted. You could have been challenged this. Once it is admitted, the coordinate bench cannot overlook
I
the.
am raising a preliminary issue, Malata.
No.
Sure.
I accepted your preliminary issue.
Yes, ma'am.
But again, the issue is that once the revisional application was filed and once it is admitted, can this court?
No, when there is a order from the coordinate bench, Malata.
Again, you are telling,
Yes, ma'am.
the question is, I am not with regard to against this order. Now the Supreme Court is also telling
Yes.
that even the anticipatory
Yes.
bail, you persons are
Has to-
directly coming
Sessions
to
Court,
the
yes.
High Court. The Supreme Court is specifically
Yes.
telling you go to the first available court. Then you, in case, then you come to the High Court or Supreme Court. Because there are several cases went to the Supreme Court also. Supreme Court has also clarified the litigant must approach the first available court. Okay, I appreciate that. But here, kindly come to the 31st of October. The
It was the
revision
order of
application
admission, Malata.
admitted.
At that time, it was not served upon me.
But once it is admission, because the
It was not
1971
brought to the-
Supreme
it was-
Court
since after
1971
admission, I am bringing this notice to the court.
1971 Supreme Court what says? Once if you are raising the objection, you have to raise the objection anywhere. Okay, you leave aside the 31st of October. Then
Yes,
you had appeared on 6th of
Yes,
March.
I raised it, Malata.
Where it is? Because the Justice Sharma was there, you not raised the
Yes,
objection.
Justice Sharma himself raised this point. The court
Where
has-
is that?
That is not reflected.
Then seek
That is not
instruction,
reflected.
learned counsel for the
But
prince, seek
No
instruction.
order on merit has been passed anything now.
Then kindly come to the
Only
20th
adjournment has
March.
been-
20th March, again the same thing has
I
happened.
sought for leave to file opposition. my
Liberty
lord.
is granted to file appeal in
Yes,
opposition.
opposition.
Okay.
I was about to take that point in
Okay,
opposition. my lord.
okay, I will decide that issue again also. And now
Grant me some, at least 5 days extension to file the opposition. I'll come with those points.
not, I will decide. The law point, what do you file the affidavit in
With
opposition?
regard to
Now
facts
you
also.
satisfied
With
this
regard to
court,
facts also, my lord.
you satisfy this court. Interim, okay, interim, it is the
Expert stage, my lord.
expertise stage and it is the discretion of the court to pass an interim order
Yes.
taking into the consideration of the affidavit. But here now come to this order was passed on 8th of July. Correct. And on 8th of July, there was an evidence on record.
Yes.
Evidence on record. That is when it was recorded. Evidence when it was recorded. 2022, 23, June 2023. Correct. June 2023. Now you come to the observation of the court. Now you come to the observation of the court. In view of the respective pleading of both the parties, in this, I find the absence of complete evidence on record. What required? When the petitioner has given the evidence and cross-examination, what further complete evidence on record? 35,000 without, you have not considered the evidence. Evidence is on record. Enough to maintain the rival condition. At this is a prima facie, nothing has come on record to show the petitioner is earning herself. Enough to maintain. But as per the evidence, petitioner is getting all these things from the opposite party, vegetable and all these things. That has not been considered.
Kindly takes it on Monday. Let me come with instruction.
Kindly come to the page 3 of the impugned order.
And if I'm not in a position to file the opposition, kindly takes it on Monday. I'll come with instruction.
Opposition, this is a law point.
Kindly takes it on Monday. I shall satisfy also. Monday.
But warrant is there.
No, Monday. I shall come.
Warrant is there.
No, kindly takes it up tomorrow then.
Come tomorrow. Counsel for the respective parties has argued the matter at length. Full stop. Then at counsel for the petitioner, counsel for the opposite party / respondent, prays for time. Let the matter appear tomorrow.
Monday.
আর কিছু আছে না? হ্যাঁ? Which for the other side? 54, 44.
ওটা কালকেই থাকবে। কালকেই থাকবে।
Give 43. Give 43. Give 43 and 44.
তারপরে
Let the record come. Item number 43. 167. Yes.
Under section 85 BLS is 498 and 109 BLS rate inside the union.
498A and
498 that is section
85. Yes, 74.
part of the outright of notice.
354.
It's the
354. Yeah, then one. Next no charge under 109. So 354, 498.
198 is
Correct.
and rate is target price.
Correct.
Managed to place in the year 2030.
All who are the all petitioners? Altogether 5 accused persons.
One is the mother-in-law, sister-in-law, and husband. The marriage took place in the year 2013.
Hmm.
One and the opposite party is number two parent.
Hmm.
It's subsequently annulled
Hmm.
by a degree of the competent court.
Hmm.
After the opposite party, the wife.
2013 marriage solemnized. When the marriage was solemnized?
6 of July 2013, the first marriage.
6 July 2013.
Petitioner number 1 and the opposite party number 2.
Okay.
It's annulled by the degree of the competent court.
When it was annulled?
Annulled on 10th of April 2017.
10th April 2017.
It's 19. On the grounds
Hmm.
that the wife is not willing to stay with the petition.
Hmm.
Now, after annulment of the marriage in the year 2020, the November 2020, they again got married.
When?
On November 2020,
November 2020.
the long persuasion of the
Again marriage.
the opposite party number 2 and the petition number 1 and opposite party number 2 again got married.
Hmm.
Thereafter, the matrimonial house of the opposite party number 2 is Calcutta. But they started residing at Chanchol Malda, where the petition number 1 is in service. So, there is a very remote introduction between the opposite party number 2 with her in-laws. Very rare occasion she went there, and after the movie period, he completely stopped with Calcutta at her matrimonial house. Now, Lordship, on 29/3/2023, she voluntarily left the company of the petitioner. 29 March 2023, she voluntarily left the company of the petitioner with all her belongings, her string of properties, and all that. On 15/9/2020, more than 1.5 months, half year, the wife lodged the complaint against the petitioner and all the process to her in-laws. Madam, the lordship pending comes to page 28-29 is the FIR. It is Bengali. Madam, the content of the FIR was that she was allegedly tortured by the petitioner. The basic allegations against the petitioner number 1. She has, the petitioner number 1 has driven out the opposite party, therefore she was compelled to take shelter of her parental house.
When, what is the date she has admitted driven out?
According to her, she has been driven out on 29/3/2023.
Same date.
FIR also that. Thereafter, she made out a case that on 14/9/2024, the husband, her house, her parental house at Bihar, the husband used the languages, and thereafter she lodged the complaint. This is the case she made out. She tried to cover up the deal. Therefore, the 14.
So what is the stage of the trial now? Charge sheet submit supplied. Charge sheet supplied. So charge has not been framed.
14/9/2024, according to her, the petitioner raised the parental house.
Correct. Okay.
Now, lordship kindly comes to page 34. Page 34, the petitioner is the number 1. He is the assistant director of horticulture. So, while the page 35 lordship, your lordship will get that on the very particular date, the petitioner was in posting Medinipu for some fieldworks on that particular day. Now, lordship signed and annexed all the documents that is page.
Where the OP2 resides? Where the OP2 reside?
900 kilometers up, 900 kilometers. It's 36, 37, 38 of the attendance registered, 38.
Okay. The petitioner has filed the present revisional application under section 528. What under section? Under section 528 of the Bharat Nagrik Suraksha Sanhita 2023, praying for quashing of the criminal proceeding arising out of Pundibari Police Station case number 731 of 2024, dated 15th of September 2024, under section 85/74 of the Bharatiya Nyaya Sanhita 2023, read with section 3/4 of the Dowry Prohibition Act, pending before the learned Chief Judicial Magistrate Sadar Kuch Bihar, being GR case number 1766 of 2024. The petitioner submits that on 6th of July 2013, the marriage between the petitioner and the opposite party number 2 was solemnized. Subsequently, on 10th of April 2017, the marriage was annulled by an order, by the order passed by, where is the order?
19 onwards, Lordship can see the order passed by the learned additional district judge Kuch Bihar, page 2021.
क्या बोला? Subsequently, on 10th of April 2017, the Learned Court of Additional District Judge, 3rd Court, Kuch Bihar, granted decree by annulling the marriage between the petitioner and the respondent number 2, solemnized on 6th of July 2013. Full stop. Again, in the month of November 2020, the petitioner and opposite party number 2 got married. On 29th of March 2023, the opposite party left the company of the petitioner, and on 5th left the petitioner. After the period of more than 1.5 years, the opposite party number 2 has initiated a case against the petitioners for the offense under section 85/74/109 of the BNS 2003, read with section 3/4 of the Dowry Provision Act. Learned counsel for the petitioner submit that the petitioner is number 1 is a government servant and is posted at Kolkata,
He is posted at
Malda.
At that particular time was at Paschim Medinipur.
Was posted at Paschim Medinipur. Though the opposite party number 2 left the house company of the petitioner on 15th of September 29th of March 2023 and is residing at Kuch Bihar, which is about 900 kilometers from Medinipur. Thus, full stop, Medinipur. He further submits that the petitioner number 2 is the father of the petitioner number 1, and the petitioner number 3 is the mother of the petitioner number 1, and the petitioner number 4 and 5 are 4 is the sister and 5 is the brother of the petitioner number 1. Sister, 4 is a sister and 5 is the husband of the sister of the petitioner number 1. All are residing much away from the residence of the opposite party number 2, but the opposite party number 2 on 15th of September 2024 has registered and made a complaint to the police on the allegation that the petitioners have tortured the respondent number 2 and demanded dowry and abused her and forcibly ousted her from her matrimonial house. The counsel for the petitioner has relied upon the certificate issued by the concerned authority, that is the district horticulture officer, dated 29th of October 2024, wherein it reveals that the petitioner was posted at Midnipur and on that day he was attended the office. She has okay. We attended the office and visited the field as Garbeta 3 block on 14th of September 2024. She has also relied upon the attendance register of the petitioner number 1, which shows that the petitioner number 1 is continuously attending the duty at Midnipur. She further submit that only to harass the petitioners, the respondent number 2 has initiated the case after the period of 1.5 years after leaving the matrimonial.
But she is taking my
Police.
support from the petitioner is providing.
She further submit that till date the petitioner is providing the logistic support and had the learned counsel for the petitioner, this court find that the petitioner has made out the arguable case and is to be decided after hearing the state as well as the after hearing the state. Police. In view of the above, the CRR number 167 of 2026 is admitted. The petition is directed to serve notice upon the state and the opposite party number, state and opposite party number, after hearing the state and the opposite party number 2. To issue notice to the state as well as the opposite party number 2 and to file affidavit of service on the returnable date. Full stop. List the matter. Full stop. Pending disposal of hearing of the present revisional application, the proceeding pending before the learned chief judicial magistrate at Kuch Bihar, being GR case number 1766 of 2024, is stayed until further order.
Regarding item number 73, may
List the matter before the next available circuit bench. Yes.
my lord,
Yes, 44.
Wash the FIR and the proceedings in present petitioners. Present petitioners are the maternal uncle and aunt of the husband. My lord, and my lord, the FIR at the end, and the only allegation is there is in the last para of the FIR.
Who is the petition number 1?
Maternal uncle and aunt.
All. No husband.
Only maternal uncle and aunt. No husband.
Maternal uncle and aunt of the husband. Sisti Pradhan. She is the wife. Yes, where is the FIR?
The last para of the FIR. Only allegation is in this para. It states that about 3/2025, my husband took me to Rajesh Pradhan's house at Jabra, Nilpani, Police Station, Panipat. This is not the address of the present petitioner's matter.
Where all
It will clearly show the address of the present.
no, where all my in-laws present. There, that is a Rajesh Pradhan, Rajesh Pradhan, Mani Kumari, so and my husband all started to torture upon me, and without any rhymes and rhythm. They started to beat with the fist and blow. Thereafter, when I started to raise my voice, at the time they started to threaten me with the dire consequences. Somehow I made a call to my mother and rescue from there my mother along with my mama, Miss Pradhan.
See, when the address belongs to the present petitioners.
So where she resides?
The present petitioner resides at stage.
No, she married to, where is the husband?
Resides at the minor within the FIR itself. From Honorable son of Banti Prasad. They reside at near Memorial Panipat, under Panipat Police Station.
Where from you got?
Resides at
Where from you got?
in the FIR itself.
Where, which page?
First page of the FIR matter. In the subject section matter. Sino Manaka, son of Kalita, Maya, Rani Tanda. Because I was a happens to the husband. Maya Rani Tanda happens to the mother. Resident real member of high school, Panighata, and that Panighata village. In present petition, she states that they are residing at Jabra, New Pani, police station, Mando. Residing at, my lord, they are residing at Nokshalban, at Belgachi, Darjeeling. That I have annexed the Aadhaar card of the same. That's in page number 60. That is my first submission. No specific allegation given against them. After 6 months, the FIR has been lodged without giving any reasonable explanation for them. She says at 3/10/2025 the incident occurred. She lodges this FIR on 26/2/2026. That is one of my points. Why does she lodge this FIR and the reasons for the same matter? Because she married the present husband, suppressing the fact that she was earlier married. And she got up on 3/10. She took the mutual divorce from her previous husband. And I added that document also. That is page number 29. And the present husband also filed a void marriage. Because
No. This, she had a earlier marriage, first marriage. Correct. That first marriage was
when she married this present.
when your marriage was solemnized.
But as per her FIR, it was solemnized on 6/12/2024.
6/12/24. Correct. And the earlier marriage was dissolved on 11/11/2025. 2025. Yes. Then.
Thereafter, she went out of the house as per the FIR.
So when you file the suit.
I filed on 17/2/2026.
17/2/2026, you file the suit
And I added the page.
for divorce.
The point.
Where it is?
Page number 23.
Section 9, section 11.
Yes. Section page 24. I added the control.
Section 11. 7/2/2026. And FIR was lodged on 26/2.
And I have filed the.
And when you are residing along with your wife, you are residing with whom? You petitioner, the husband. Okay.
She is residing in her father's house.
Okay. The petitioner has filed the present application under section under section 528 of the Bharatiya Nyaya Suraksha and BNSS 2023, praying for quashing of the proceeding initiated against the petitioners in connection with the Darjeeling, in connection with Mirik PS case number 6 of 2026, dated 26 February 2026, under section 85/316 within bracket 2/351 within bracket 2/3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023, pending before the learned court of Additional Chief Judicial Magistrate Mirik, being GR case number 7 of 2026. The counsel for the petitioner submits that the petitioners are the maternal uncle and aunts of the husband of the opposite party number 2. The opposite party number 2 has made a complaint to the police of PS Mirik on 26th of February 2026 only on the allegation that on 3rd of October 2025, on the allegation that her husband took her to the house of the petitioner number 1, petition at Jabra Nirpani, Panihata, where all the in-laws were present, where all the petitioners who are the in-laws of the respondent number 2 were present, wherein all the in-laws have torture upon her without any reason and also assaulted her with fist and blow with fist and blow and also threatened with dire consequences. Counsel for the petitioner, number next, no? Counsel for the petitioner submit that the respondent number 2 had married earlier and only on 11/11/2025 the marriage of the respondent number 1 was dissolved by way of decree of divorce in mat suit number 76 within bracket 8 of 2024 by the Court of Additional District Judge. The respondent number 2, by suppressing her first marriage and during the existing of her first marriage, had married to the present husband, to what is the name? To Subham Agrawal. When the Subham Agrawal came to know about her existence of the first marriage and the Subham Agrawal has filed a suit before the district judge on 17th of February 2026 for declaring the marriage between Subham Agrawal and the respondent number 2 as null and void. When the respondent number 2 came to know about the divorce petition filed by Subham Agrawal, the respondent number 2 had initiated the instant case against the maternal aunt and uncle of her husband only to pressurize the her husband to withdraw his matrimonial suit. Full stop. Consider the submission made by the counsel for the petitioner. This court finds that the petitioner has made out the arguable case, and as such, this case is to be decided after giving an opportunity of hearing to the state as well as the respondent number. Accordingly, CRR number 168 of 2026 is admitted. Petitioners are directed to serve the notice upon the respondent number 1 and opposite party number 1 and 2, and to file affidavit of service on the returnable date. Pending disposal of the present date application, the proceeding pending before the Learned Court of ACJM, Mirik, Darjeeling, in connection with GR case number 7 of 2026 arising out of FIR 6 of 2026 dated 26 February 2026 of Mirik PS case dated Mirik PS case is stayed until further order.
May we permit to
Is
mention
the
item number
matter
73?
before the next available circuit bench. Yes.
My lord, regarding item number 73. My lord, my junior is there, affidavit service is ready, my lord. There are 3 FIRs.
70.
73. There is an interim order. There is an interim order. My lord, kindly fix the date and fix for hearing and extend the interim order. Why filed 3
Come
FIR?
tomorrow. I will take tomorrow. Come tomorrow. I will take tomorrow. No problem. Come tomorrow.
Yeah, come tomorrow.